Sir mention.
Permit to mention the matter, item number 46 of today's list, my lord. 42 of the today's list, my lord. My lord, with the consent of the senior counsel, my lord, kindly fix the matter on 17th at 2 p.m., my lord.
I am the respondent award holder. My learned friend and his learned senior are in difficulty. That his learned senior.
Well, I have some personal difficulty, man.
I have said that their prayer is that my lord will kindly fix it on some day, 17th. They are suggesting at 2 o'clock.
And Mr.
Or
Mitso,
any other time. So to that extent, I have given consent that I have no difficulty.
Can't be fixed on a particular time.
perfect date, my lord.
But why 17th? What's so auspicious about it?
No, my lord, senior counsel, my Joyantri Mitra has also consented that on 17th. After discussion, then, my lord, we are saying, my lord.
No, I do not know.
Is your senior traveling from outside or what?
Yes, sir, my lord. That is, I have some difficulty. My senior also some difficulty. That is when we're mentioning. Unless,
Mr. Abratosh Mojumdar, who is leading my learned friend, told me that he will be away from Calcutta for a fortnight. So that is why perhaps the 17th.
Yes, my lord.
That's why you are asking the 17th. Which item is this?
42, my lord.
Commercial.
All right, we'll have it on the 17th, but no time fixed.
Very
grateful, man.
Deeply obliged, man. Great. May I have the Lordship kind leave to mention the execution application, Lordship. This application was there are two execution applications arising from the one arbitration proceeding, Lordship. Both one application was assigned before His Lordship, the Honorable Justice Sampa Sarkar, Lordship, and one was not. So she was unable to take another because it was not assigned to Lordship. So we have got it released, both the applications, to be listed before this Honorable Court, Lordship.
That the Honorable Chief Justice will do it.
No, Lordship will see the direction is the petitioner for the petitioner prays for release so that the matter can be released, placed before the regular bench, having the detailed information as per the assignment. So Lordship has the regular bench, Lordship, to hear out this applications, Lordship. So, and in Secretariat also, Lordship, before in the office of the Honorable Chief Justice, they say that for you mention, if an Honorable Court does not accept, then you give a letter. So upon mentioning, I'm mentioning this, Lordship.
You mention before the Honorable Chief Justice, matter has to be marked here.
Lordship.
Matter has to be marked.
So Lordship has a determination of regular bench. That is what I was praying.
Coordinate bench can't send the matter here like this.
Lordship.
It has to go to the Chief Justice and then the matter has to be marked here.
Deeply.
To mention my lord for execution case.
Sorry?
Education case, my lord, for upgradation.
Upgradation, not right.
I have Lordship kind leave to mention section 9. It perhaps to appear, my lord, in this monthly list. But this matter is not appear. Section 9.
Section 9. Yeah, just take.
May be permitted to mention one contempt application of Group 5 matter, my lord.
Contempt application.
Last week I had Lordship, my lord. They are not releasing the gratuity as well the pension, my lord, even after your Lordship's direction. Even after 6 months, my lord. 6 months elapsed from your Lordship's direction.
Give us a
My lord, execution matter.
Give the slip, we'll see that.
My lord, execution matter newly filed, my lord, not listed yet for inclusion.
Inclusion.
May I have your lordship leave to mention a matter for inclusion, execution application, lordship arbitration award passed by the MS.
Give your slips, we'll see.
With my lord's kind leave, may be permitted to mention item 21 of my lord's commercial list. I'm mentioning upon notice. The interim order expired yesterday, my lord. I'm seeking an extension of the interim order. It's my section.
Come, we'll see that when it comes.
My lord, item 21. My lord.
We'll see. There's no need to mention.
In case it's not taken up, may I be permitted to mention at 2 p.m. today?
We'll see that.
I'm grateful.
May I be permitted to mention an appellate side contempt matter, your lordship? Your lordship has previously asked me to come after 3 weeks. So, your lordship, the municipal. Grateful, your lordship.
On 2 executions matters, there's inclusion matters.
Inclusion.
Section 34.
34, wait.
Lordship's kind indulgence to mention this matter, my lord. Lordship has granted me liberty to previous week to mention this. This is a part-time matter. My lord, doctors have retired. They're not being paid the pension and benefits, retirement benefits. They're covered by Lordship's order. Lordship kindly take it any day, subject to Lordship's convenience. Lordship remembers that matter, all analogous matters.
Give this.
Lordship, may I be permitted to mention an execution matter, Your Lordship, for upgradation? Lordship, the section 37 has been dismissed for default long back. They are not taking any steps, Your Lordship. Only thing remaining is for the execution, Your Lordship. It's a 2023 matter. Kindly, Lordship.
May I be permitted to mention one execution matter? It's a fresh matter for inclusion.
My lordship, I am permitted to mention an appeal arising out of arbitration order dated 6. Kindly
34.
mention the
Wait for a while.
May I be permitted to mention one matter for correction, Your Lordship? Your Lordship would recall this matter. Your Lordship passed an order on Friday. It's my execution application. However, Your Lordship, the account number is wrongly typed, Your Lordship. Because of
To be mentioned tomorrow.
grateful, Your Lordship.
Make the correction in the slip only. Give the right account number.
We have written, Your Lordship.
May I permitted to mention, Your
Tomorrow to be mentioned.
for inclusion, the execution application.
Give the slip.
My lord, may I be permitted to mention? I'm mentioning on notice, my lord. This is section 34 application. I am the respondent award.
Before, wait for a while, madam.
My lord, the only difficulty, my lord, I am suffering a stay and the company is in liquidation, my lord.
Wait for a while.
May I, Your Lordship, mention before your court? It's an execution matter. It should be included in the list. It's a
Give the
fresh
slip.
matter.
Give the slip. Give the slip. We'll see that.
May I have your Lordship?
What is the urgency? When did you file the section 9? Give the slip.
They are trying to mention one matter for urgent listing under section 14 of the Arbitration Resolution Act, Lordship. The urgency being, Lordship, the respondent is an NBFC. They unilaterally proceeded to appoint an arbitral tribunal. We have objected. Despite our objection, within 7 days of notice or under section 21, arbitral tribunal has been constituted. They have filed their application for interim injunction. And Lordship, there's every
Go before the tribunal.
Lordship, it's a unilaterally appointed, Lordship. It's completely beyond section schedule 12, 14 and Supreme Court, Honorable Supreme Court judgment of Perkins. It could not have been, Lordship, and they have not given us section 21 notice was given 30 days not complied with. We objected to the nomination of the arbitral institution, which is SAMA, Your Lordship. It is not even an arbitral institution which is graded or recognized by this honorable court, Your Lordship. Lordship, this despite our objection, they're proceeding with it and they'll
Give us the.
May I have your Lordship's leave to mention a matter? My lord, I appear for the judgment debtors. My lord, warrant has been issued against me by an order of 25th September 2025, made returnable in the monthly list of December. Now, the judgment debtors are present in court. My lord, they did not receive any award. Only the execution application was served on them. If the warrant could be discharged, my lord, they are present in court. They will be present in court, my lord, henceforth subject to the leave granted to your lordship.
We'll see that. They have to come
Yes,
on
my lord,
the
they will have to surrender before the sheriff. If your lordship could pass a direction on the sheriff so that they are present in court today, so they could go to the sheriff and surrender themselves, and the warrant may be discharged. Because otherwise, they would pick them up and
Even if they appear before the sheriff, they have to appear before court also.
yes, they will have to. They will be
Yes.
present. They will be present.
So
But
let them come on the next date, whenever the date is. What is the date?
monthly list of December. So this is the date, and execution proceedings your lordship takes up on Thursdays.
They can always go and surrender before the sheriff. You don't need an order from the court for that.
But generally, the sheriff is not inclined. But we shall try. If it is not
Go before
possible,
the
we shall
sheriff.
come before your lordship.
Lordship, may be permitted to mention an execution matter for non-prosecution.
Not be inclined.
That
Is the
that's
direction
what
passed?
usually happens. But
Not
but
at all.
we'll try.
I've been taking these matters every day. How can he refuse?
But we'll try, and then
Question?
we'll try. Well, otherwise we'll
Take
come.
the sheriff to the task. Can't do that.
Very well.
This is the order of the court. It's
Yes,
not
ma'am.
his prerogative.
Yes.
Lordship, mentioning execution matter for non-prosecution.
Call out the matter.
My lord, I'm appearing on behalf of the petition in this matter, my lord.
My lord, I'm praying for a short passover. My senior is
First
on
matter pass over.
she's about to reach, my lord.
What? You look at the watch. I mean, how? From tomorrow onwards, put in the list first 10 matters. No Passover. We'll dismiss. There's no question of asking for a passover in the first matter. Please have some respect for the court.
Apologies, my lord.
10:51, your senior has not reached. This court sits 10 minutes late only to accommodate the lawyers.
My lord, apologies, my lord. She's about to reach us.
And then also the lawyers will make a request that at 10:52 also they can't make it to the court. Then we should stop sitting. You assist the court.
My lord,
Not today, monthly list January.
my lord, this is my petition, my lord.
Oh, what nonsense this is. There's no time. There's no respect for the court. First matter in the day, and you're asking for a passover. What time does your senior reach court? 1 o'clock.
No, my lord. Generally comes.
What is this?
Apologies, my lord.
Yes, you start.
My lord, this is my application under section 14, my lord, terminating the mandate of the arbitral tribunal, my lord, that was appointed at the behest of the, my lord, the respondent. My lord, this is my case. And your lordship will kindly take, my lord, page number 10 of my petition. My lord, this is the first notice without invoking section 21 notice, my lord. This is the notice that I get, where, my lord, I come to know that already an arbitration proceeding has been initiated, my lord, by the my lord, online, my lord, if this is a forum, my lord, online system generated forum, my lord. That's what, my lord, the representation was by the respondent. Now, my lord, this is the first notice. If your lordship kindly takes the date once, 10 July 2025, my lord. And thereafter, the lordship page 11, page 10, my lord.
Yes.
And thereafter kindly takes the page 11, your lordship. And subsequently, I come to know that an order has been passed without my presence being recorded by the tribunal. Your lordship will also find from page 13. This is another procedural order that was passed on 28 July 2025, where I was not
I
a
remember she was arguing that it is
yes,
maintainable in view of. Where's the file?
My lord, it is
Where's the
actually
file?
my lord.
My lord, her contention was in view
How
of
can you appear without a file? I understand your senior is not here. You are appearing? Where's the file? How can you come to the court without the file? How many years in the practice?
My lord, I'm starting out now.
This is how you appear in the court without the file. You don't even carry the file to the court.
I actually have it in my, if I may.
you require a file.
This is really.
Take this. Apologies, my lord.
Watch. Let them file their reply.
My lord.
We'll stay the proceedings. The petitioner has preferred the present application under section 14(2) of the Arbitration and Conciliation Act.
Petitioner.
What is this, Mish?
Reply with the version.
First matter in the day and your
47 also it was called, not sure.
first matter of the day.
My lord,
File your reply.
Stay
the process. 14(2) of the Arbitration and Conciliation Act 1996, challenging the mandate of the learned sole arbitrator, unilaterally appointed by the respondent for adjudication of the dispute between the parties. Full stop. And ask your colleague to carry file at least to the court. Full stop. Learned counsel for the petitioner submits that the respondent appointed the sole arbitrator unilaterally, without any participation or consent of the petitioner. Full stop. It is further submitted that as per the arbitration clause contained in the contract executed between the parties, the sole arbitrator was to be appointed through any online dispute resolution forum. Full stop. However, the respondent, acting unilaterally, selected one ODR platform, namely ODR,
There's no name.
platform, namely Presolve 360, right? Inverted comma Presolve. PRESOLV 360. Yeah.
I feel if it will go through.
And the Presolve 360 and appointed learned sole arbitrator Ravi Veera Raghavan. Ravi Veera Raghavan.
That's why you could not tell anything.
If my lord so pleases, my lord, the petitioners were never aware of the name of the ODR, my lord.
Is there in your
Lordship, I object to that.
Lord.
I object to that.
is there in your petition only?
Yes, my lord. Later we have come to know, my lord.
Yes.
Very well.
Lordship, if 15 minutes
Full
would be
stop.
given to
And
me,
and appointed so and so without consulting or notifying the petitioner. Full stop. It is contended that such unilateral appointment is contrary to the agreed procedure and violative of the principles of natural justice. Full stop. Learned counsel for the respondent seeks and is granted a period of 3 weeks to file her affidavit in opposition.
Lordship, I can do it in 2 weeks.
2 weeks. Reply to the same, if any, within 1 week thereafter. List after 4 weeks. In the meanwhile, further proceedings before the learned sole arbitrator, Ravi Veera Raghavan, in case ID number A271955, shall remain stayed for a period of 8 weeks. List the matter after 4 weeks.
Deeply obliged, my lord.
In item number 2, my lord, I beg to appear for the petitioner, my lord. This is my application under section 27(5) of the Arbitration and Conciliation Act, my lord. I am the claimant before the arbitration proceeding, my lord. I had filed a section 17 application which was allowed, and there was a direction upon the respondent to produce the RA bills and certain documents, other documents. That was not complied by the respondent, so we filed an application, moved an application before the arbitrator seeking a leave to file an application before my lord to find them in contempt. So that application was allowed by the learned arbitrator, the leave was granted, and after having obtained that leave, we are before my lord under section 27(5), my lord. If my lord takes page number 187, that is my first initial section 17 application which was allowed, page 187. If your lordship has page 187, then I'll take, yes, ma'am.
Yes.
Then, my lord, I'll take my lord to the prayers, which is at page number 206.
Yes.
My lord, the first prayer was, my lord, interim order directing the respondents to forthwith disclose all particulars of the RA bills raised against Rapid Scan System Private Limited, along with particulars of the status of clearance. Second was again make over and give access to the books of accounts, and further direction upon the respondent producing all records showing the revenue. So these were my threefold prayers, my lord. This was allowed, my lord, vide an order dated 10 June 2025. Your lordship will find that order in page number 231, which was passed by the learned arbitrator.
Page number?
231, my lord. And the relevant portion of the order, your lordship will find at page number 241, para 22. Para 22. If I may read, my lord, the respondents are therefore directed to disclose the particulars of the RA bills raised against the Raspican system pursuant to the notification of award dated such and such, along with particulars of the clearance thereof. The respondent shall also disclose their books of accounts, profit and loss, and balance sheet. The respondent shall also validate all the records of the total revenue generated by them in furtherance of subcontract dated such and such, between such and such. The duly validated records shall be submitted to this tribunal within 16 June 2025, and copies of the same to be forwarded to the claimants. So, my lord, my threefold prayers which I pursued in my section 17 more or less was allowed by the arbitrator, my lord. Thereafter, my lord, there was a violation. No such documents came forward by 16th of June. I preferred an application under section 27, my lord, before the arbitrator. Your lordship will find it at page number 242. This is before the arbitrator. And the relevant prayer, my lord, is at 273. This is where I seek leave from the arbitrator to file this particular application before my lord. Page 273, my prayer starts. If your lordship has it, make a representation to the Honorable High Court at Calcutta having jurisdiction over the subject matter and thereby requesting the Honorable Court to hold the respondents in contempt and such, owing to the violation of the 10th order June, 10 June order.
Yes.
There, my lord, after that, on this application, my lord, your lordship will find the leave granted in page number 278. We did the order dated 21st of August 2025. And the relevant portion, my lord, is at page 280. Para 11, 12, 13, my lord, if I may, my lord. In spite of granting adequate time, the respondents have failed to comply with the order and today have neither attended nor intimated this tribunal about the inability to attend the meeting or to take necessary steps for compliance. Under such circumstances, leave is granted to the claimants for the ends of justice to act on this approval under section 27 of the Act for taking necessary steps. Pursuant to this leave, my lord, I am before my lord.
No. Yes, sir, the other side.
Lord, contempt. If your lordship finds, then rule may be issued.
And the petitioner has preferred the present application under section 27(5) of the Arbitration and Conciliation Act 1996, seeking direction to compel the respondent to purge the alleged contempt by complying with the order dated 14/5/2024 passed by the arbitral tribunal. Full stop. Learned counsel for the petitioner submits that the arbitral tribunal by its order dated 21/8/2025 granted liberty to the petitioner to take appropriate steps in view of the respondent's continued non-compliance with the tribunal's earlier order dated 11/6/2025. Full stop. On the strength of such liberty, the present petition has been filed by the petitioner. Full stop. It seems that the respondent has been acting against the mandate of the tribunal and has failed to comply with the orders passed by the tribunal. Full stop. Let the respondent file their affidavit within a period of 4 weeks. The rejoinder, if any, within 2 weeks thereafter, list after 6 weeks.
No, the tribunal's order is 10 June, not 11 June.
10th June.
10 June.
Tribunal order dated 10th June, not 11th June. Non-compliance of the order dated 10th June. 10th June, not 11th. 10th. Okay.
I'm so grateful, my lord.
This is my application, my lord. Series of application, my lord, under section 34, and my lord, 2 of them, my lord, under section 9 filed by them. My lord, Mr. Sen had, my lord, started his arguments. My lord, this is that matter where, my lord, jute was, my lord, supplied. Yes, my lord.
Yes.
Jute was supplied. My lord, prior to, my lord, going into, my lord, the law points, which was, my lord, addressed by Mr. Sen, my lord, if your lordship, my lord, on equity, my lord, kindly, my lord, bears with me, my lord, kindly allows me, my lord, to place, my lord, the contract, some of the clauses, which will show that, my lord, the contract itself.
We'll have this matter at 12. All right.
Yes, it will take some time, my lord.
That's
In
why
fact,
we'll
my lord,
have-
if your lordship, my lord, kindly
we'll
permits
have
me
it
to
at
come
12.
back.
No, we'll start at 12. We'll finish the lunch. After lunch, we'll finish it off.
May I, my lord, come back at 12:30 if your lordship so permits me, my lord?
12:30.
I'm so grateful. I'm so grateful. 3, 4, 5, 6 mona hai acumen.
There's 3 to 6, right?
Till 6.
3, 4, 5, 6.
3, 4, 5, 6. Yes. 12:30.
Lord, in item number 7 and 8, my lord, I am for the respondent.
You have any objection to the application?
Yes, my lord, I do. My lord, pleadings have been completed in this matter. The lordship would take the order dated 13th August 2024 that has been passed by Justice Bhattacharya, my lord.
Page?
My lord, it is part of the order sheet, my lord. That, my lord, records my lord, objections to the application. And I should indicate it to your lordship. Your lordship would recollect.
I'm filing reply. Yes.
There was that previous matter of section 11 being read along with section 29A. I had indicated to your lordship, my lord, that the judgment has been reserved by the Supreme Court in this issue. The self-same issue is involved here.
We'll wait.
Yes, my lord, that is, my lord, should I share with your lordship? That
That is at 1094 something.
But I am filing the opposition, my lord. I am just sharing your lordship's last order which records that. Judge Sahib, agar order ta de.
Are you filing a reply to this?
I have filed reply, my lord. Just now I have filed, my lord. I am placed by Mr. Rohit Banerjee. I am
Supreme Court issue. But I am just sharing the order.
in the
Take down.
I'll just share the details. Of
Yes.
I Supreme Court.
दे दीजिए मैं.
कि Supreme Court जगह हट के आते कितने आजम
फिर दो check कर दिए.
Yeah, okay.
And this is my lord's order.
Yeah, okay. What are you showing? Give us a copy.
Yes, sir. I'm giving it to you.
Out of what?
So this is from Sheila Cholgule.
All right, take down.
Another matter.
We'll wait for the
I don't know what this matter is all about, Mulud.
same 29A. We have been taking a view. So our view is based on this, the Bombay High Court judgment that has been challenged in this.
But then the Supreme Court has passed a judgment saying that, my lord, the court having jurisdiction under 21E would be the court taking up 29 applications. There's a judgment of the Supreme Court.
We have seen that judgment. That is what people have been relying upon. The
Yes, ma'am.
NH roadways that
PWD
PWD. This is that's just kind of a bitter kind of.
But that judgment is not set aside, my lord.
I know that. We'll have this. This one makes more sense because this has distinguished. The Bombay High Court had distinguished. The coordinate bench of this court has distinguished. I have distinguished. We all have taken a different view.
But there is one Meghalaya and one Allahabad High Court also, my lord.
Correct. So there have been contrary views on this. So
In
let
fact,
this
your lordship had considered all the judgments in your lordship last order.
yes. So we'll wait. Matter of it's been reserved. Take down. The affidavit in opposition filed by the respondent is taken on record. The reply to the same is also taken on record. Full stop. ये order court करता हूँ since.
এইটার জন্য পেন্ডিং রাখছি এইটা দেখ
We'll keep it in the monthly list of January.
In the item number 8, well, same order, well, I am also filing my opposition there.
I'm also filing supplementary affidavit and reply. In item number
Item 8, affidavit in opposition, reply to the same and supplementary affidavit. All are taken on record. The same.
অলরেডি জাজমেন্ট আছে আবার একটা
List in the monthly list of January.
সেই জন্য একটা জাজ বলছে যে জাজমেন্টের জন্য ওয়েট করছি
Both 7, 8.
এটা দেখো না কবেকার অর্ডার এটা গ্রেটফুল মানে
Grateful to your lordship.
ওটা দেখে নে
Well, item number 9, I appear on behalf of the petitioner, my lord. But on the last occasion, the matter was taken up on 16th of December, my lord, 2024. There was a direction for filing affidavit of opposition, but that opposition has not been filed yet by the respondent. And there's a moratorium supposedly that was going on, and they are trying to extend the moratorium in the NCLT, my lord. But this is the last order of the NCLT which I have got from the website, my lord. Matlab, they are not appearing on various time and that 180 days time has already expired, matlab. Uh, 9th of July, my lord, the mandate has expired of the arbitral tribunal.
They're not here.
My lord, they are not appearing on all the occasions, my lord. Last time on the December, there was a direction for opposition. They have not filed their opposition yet. And my lord, this is the last order of the NCLT, my lord. And now my lord, the mandate has expired. Also, the period of moratorium, which is 180 days, that expires on 16th of June 2024, my lord. After the moratoriums.
Speak with Mr. Lakhani. We'll see that.
My lord.
We'll keep it for tomorrow. Speak with him.
My lord, the day after, my lord.
Day after tomorrow. Not today.
Well, we'll first serve a notice on the other side. Grateful, my lord.
Not today.
Grateful.
Lordship, item 10, this is my application under 29A.
Yes.
Lordship, for extension of time. Lordship, the pleadings were completed on 17th of April 2023. Thereafter, the mandate, if my lord, expired on 17th of April 2024. By consent of the parties, a 6-month extension had happened. That also expired on 16th October 2024.
Yes.
Your Lordship, I'm being led by Mr. Ishan Shah. He's on his legs, Your Lordship. I'm praying for a short passover, Your Lordship.
You're challenging the mandate.
Yes, Your Lordship.
All right. Not today. Tomorrow.
Very well.
This is my section 9 application. They were to file their opposition.
My lord, I will be seeking, my lord, 2 weeks time to file my affidavit in opposition, my lord. There are two matters, my lord. One is item number 11 and one is item number.
Banerjee, what steps have you taken for constitution of the arbitral tribunal?
There is no order.
There is no order.
We have filed the section 11 already, but they are contesting, and in section 9 there is no order. So time has not even started.
So, my lord, here the order was of 22nd September. My lord, time to time, my lord, the petitioner has taken some time to file, my lord. They were seeking time to file the supplementary affidavit. On 22nd September, my lord, the petitioner has finally said that they don't want to file a supplementary affidavit in this matter. My lord, your lordship will find from the series of orders, my lord, June and in May. So, my lord, last of order records, no such supplementary affidavit to be filed. We have prepared the affidavit in opposition, my lord. We'll have it affirmed from the client and we'll file it, my lord. Just 2 weeks time. That is, my lord, in item number 11. So far as 22 is concerned, my lord, opposition is filed and, my lord, the affidavit in reply if they wish
Both
to.
the matters together, my lord. I have to file a reply there. I'll file it.
Yes, my lord.
Learned counsel for the respondent seeks and is granted 2 weeks time.
My lord.
2 weeks time to file his affidavit in opposition. Reply, if any, within 1 week thereafter. List after 4 weeks. List in the monthly list of January.
My lord.
Learned counsel for the respondent in the other matter. Next one, right?
Item number 22, my lord.
My lord, we are respondent in both the matters, 11 and 22. My lord, my learned senior is for the petition.
You are seeking time to file your reply.
Reply in that they have filed their opposition, my lord. I'll file my
22 May, learned counsel for the petitioner seeks and is granted 2 weeks time.
Same time, my lord, so that both the matters can be taken up on the
2
same
weeks,
day.
item 22. 2 weeks time to file his reply to the affidavit in opposition. Let these matters be listed together in the monthly list of. Yeah.
Lordship is kept it, my lord, in January. Great.
Lordship, I am appearing on behalf of the petitioner. Under the instructions of the finance company, I am praying for 1 week's time to produce the bank account details. And currently, Lordship grants 1 week time at least.
Why you are taking time and time again? What steps,
Lordship, kindly.
what steps have you taken for invocation of the arbitration proceedings? This is section 9.
Yes, Lordship, kindly, Lordship.
What
Kindly.
steps have you taken, madam? Take down. Learned counsel for the petitioner seeks and is granted. 2 weeks time as last opportunity to furnish bank account details of the respondent. List after 3 weeks. 3 weeks.
3 weeks.
For item 13, I appear for the petitioner. I'm praying for 1 day's time to extension to file my affidavit in reply. Now, the concerned person was out of station. It's ready. He's coming today, my lord. We shall affirm it tomorrow and serve it to them. If your lordship's business so permits, my lord, kindly keeps it on Wednesday or any other day. And my affidavit is otherwise ready. Just time till tomorrow.
Reply to the affidavit in opposition.
Do we need it? That's the question.
Yes, we need it. It's ready. The person is not there. Only time till tomorrow.
What steps for constitution of the arbitral tribunal?
None to my knowledge, but I may be.
We have issued the section 21 notice. We haven't.
No.
But why not?
That should, then that's the first ground.
Why not? Mr. Gupta, tell me one thing.
Yes, my lord, we shall.
Section 9
issued today.
Section 9 is filed and then no steps are taken. This is
We are really not enjoying any interim order.
The
I will be pressing for one.
But still,
objective of the proceeding is to
want the
Your lordship is absolutely correct. Yes.
No, my lord. They want an interim order to pressurize my client to a settlement.
That didn't happen.
That didn't happen.
Now
it may happen.
I will still be pressing for that. But that does not, my lord, absolve our my lord, duty to issue the 21 notice and take steps for the arbitration. I completely. I will do that. Kindly keeps it on Wednesday. By that time, we shall comply with both our my lord, defaults and come back.
The way you're filing section 9 looks like, just trying to get an interim order and not go beyond that.
No, we are trying to get an interim order, but we also want to go beyond that.
No, but
That's I understand.
the day you come to the court, then after that,
But I appear for the respondent.
then you have to take some steps to.
Sorry, I did not say Mr. Chaudhary. I'm sorry. I'm sorry.
No.
All right. Learned counsel for the petitioner seeks and is granted 1 week time to file his reply to the affidavit in opposition. List after 2 weeks.
I can do it by tomorrow. Just 1 day. 1 day time. He was out of station. He's coming today.
All right. It's okay. After 2 weeks.
Great.
Grateful.
Take steps, Mr.
Yes. Grateful.
Grateful.
Lordship, on behalf of the petitioner, it is a Section 9 application. On the last date as well, we have submitted our affidavit of service. Since respondent number 1 did not appear, Your Lordship had directed us to serve through paper publication. This and affidavit of service, it has been effected on 28th of November. Lordship, I have annexed the 2 pictures of the paper publication, as well as Your Lordship 21 notice under Section 21 was earlier not served. We have served, and it has been delivered upon respondent number 2 and 3. Respondent number 1 similarly has come back returned. This is a copy of that Section 21 notice with details, Your Lordship.
So what do you want today?
Your Lordship, we have already obtained an injunction on the asset, Your Lordship. We are praying for prayer A, that is appointment of a receiver, if at all that is possible, Your Lordship. They took a loan of about 60 lakhs. Their that is pending amount is 60 lakhs and 31,000. Injunction has been given so that third party interest cannot be created. We are praying for appointment of any receiver by this as this honorable court may deem fit on the secured asset. That's a printing machine, Your Lordship.
(2025) matter.
Yes, Your Lordship.
When did you issue the 21 notice?
Notice was issued on 19th of November, Your Lordship. 19th November 2025.
Yes, now you have issued.
Yes, Your Lordship. After the order of the last date, Your Lordship. But within the 90-day time limit, Your Lordship, from the obtaining the injunction of Your Lordship. And on 20th, it has been 21st, it has been served upon respondent number 2 and 3. But respondent number 1, it has come back to me with addressee left without instructions.
So appoint the arbitrator, start the process.
The Section 21 notice has just been sent, Your Lordship. So I'll have to wait some time at least before filing a Section 11 application or something.
Take down despite service, none appears for the respondent. Affidavit of service is filed by the petitioner. Service has been effected through paper publication. Full stop. By order dated 25th August 2025. This court injuncted the respondent from transferring, alienating, encumbering, or changing the nature and character, or creating any third party interest in respect of the hypotheticated asset bearing number 20008809334, which is a movable equipment and machinery being an 8-color rotograph printing machine made by Cole Converting Machinery Private Limited, model number Cole 15088. ये order में लिखा हुआ है यहाँ पे 25th August ये हाँ take it from the order, ठीक है, till 30th 11/2025. Considering that the claim of the petitioner that a substantial amount of rupees 60 lakhs is outstanding, as there has been a default in repayment, and there is no appearance on behalf of the respondents, this court deems it fit to appoint a learned receiver to take possession of the said hypothetical asset, full stop. So and so is appointed as receiver to take possession of the asset, file a report before this court on the next date, full stop. And official of the petitioner shall accompany the receiver for identification of the asset, full stop. The receiver shall be entitled to receive an amount of remuneration of rupees 50,000 apart from traveling cost and other miscellaneous costs which shall be paid in advance to the receiver, full stop. The officer in charge of the concerned police station shall render all necessary assistance to the learned receiver for taking possession of the asset, full stop. Let this matter be listed on dash and dash after 3 weeks, 4 weeks?
4 weeks, Your Lordship.
After 4 weeks for the report of the receiver. The petitioner is directed to take immediate steps for appointment of the arbitrator in terms of the arbitration clause. List after 4 weeks.
Grateful, Lordship.
I think, Mr. Lakhani, there was one more matter where you were supposed to appear today.
Milord, today,
Or I could
Milord,
see
there
your
are Milord matters which will be called subsequently when I'm to appear. But
one
Milord,
matter where I'd asked the other side to get in touch with you.
very well, Milord.
Lordship, kindly make it not today because my arguing counsel is not present today on medical ground.
Medical ground. All right.
Milord, the truck. Milord, let there only, Milord, be a direction that they won't alienate it. That's my only apprehension. Because, Milord,
This time he said that he will not.
he did undertake, Milord, but it didn't go into, Milord,
We'll have it tomorrow.
the order.
Tomorrow.
Tomorrow?
Yes, I will come back tomorrow.
Don't sell the truck.
Tomorrow, Milord. Tomorrow. Grateful.
Not today.
That's okay.
For the petitioner, my lord.
Yes, yes.
যদি বলেন আপনি বললে আমি কিছু বলতে পারবো না
It has suddenly appeared, my lord. It was not trying to make excuses, but kindly take it up sometimes next week, my lord, if it is. It's a Section 9 application, my lord.
Let it appear in the daily list.
It is a Section 9 application, my lord. They have filed EC execution case. And my lord, it's
I'll
a
try to
foreign
satisfy
award.
you.
It's a foreign award. First, my lord, the hurdle of Section 45, those have to be crossed, and then only, my lord. But be that as it may.
At the request of the parties, let this matter be listed. When do you want? Mr. Mitra, when do you want?
Can it be on 12th, my lord, if it is not?
12th,
On the 12th.
11th.
11th is execution days.
Should do execution.
12th, ঠিক টাইম ফিক্স করে নেবেন
नहीं हाँ Thursday, the 11th Thursday, December. 13th?
13th is a Saturday. 13th is a Saturday.
Oh,
13th is a Saturday, sorry.
15th, well.
15th?
আগে
We'll have it on the 15th.
15th, well.
15th? 15th.
Right, number 17 is my application under section.
Milord, I appear for the respondent in the matter, my lord.
In this matter, my lord, I am asking for enhancement of the occupational charges. The defendant are occupying the my property. I am using it as a warehouse. Now, my lord, there were prior orders of this court under section 9 fixing occupational charges. I am seeking enhancement of that. On the day of hearing, my lord, they took a point of jurisdiction that the property is outside the jurisdiction of this court. So this court may not have jurisdiction, and accordingly, according to them, the Rajarhat Commercial Court would have had jurisdiction to deal with this matter. So we went before that court. Matter was argued and it was held in my favor. And Rajarhat Commercial Court has held that this court has jurisdiction. It does not have jurisdiction. That is the order. Challenging that order, they have filed civil revisional application which is pending. There is no order of stay. So there is no bar in proceeding with this section 9 application as on this date. Now, my lord,
I'll just quickly indicate, my lord, the facts of the case. My lord.
Yes.
There's
But
a
I'm telling the
2004.
order.
There's a 2004 lease. The lease instrument, my lord, contained an arbitration clause. There had been, despite the arbitration clause being shown contrary, they have appointed the arbitrator unilaterally. Thereafter, my lord, the matter went into arbitration. 2008, 2009, the arbitral award passed. In 2010, we filed the section 34 application before the Barasat court. Now, my lord, 2009, they filed a section 9 application. Now, my lord, the relief which has been sought for in the arbitration proceedings, my lord, was for recovery of the suit premise, the subject premises. Now, that form is absolutely outside the jurisdiction of this honorable court. The property, my lord, is located at Joshua Road, which is outside the jurisdiction and falls within the jurisdiction of Barasat court, my lord, prior to the commencement of the Commercial Courts Act. Now, my lord, the section 34 application was filed in 2010. They relied on a section 9 application which was dismissed when we did not have the opportunity to take the point of non-maintainability of the section 9 proceedings before this honorable court in view of the jurisdiction. They had filed a subsequent section 9 application in the year 2016. Post-award, my lord, wherein the learned single bench at that given point of time had been pleased to hold that this honorable court will not interfere with the matter since the section 34 matter is pending before the Barasat court. My learned friend's client goes up in appeal, wherein the honorable division bench had been pleased to hold that the issue of jurisdiction, because my learned friend's client had also taken out an application, my lord, apropos, my lord, in terms of section 42 of the Arbitration and Conciliation Act, saying that this court had exercised prior jurisdiction, though, my lord, the section 9 application was dismissed. In my absence, it was dismissed. I had not participated in that particular proceedings. Now, my lord, the division bench had held that the matter would be decided by the learned trial court, which is the section 34 court at Barasat. Subsequently, my learned friend's client filed an application under section 15(4) saying that the commercial court at Rajarhat will have jurisdiction because after the commencement of the Commercial Courts. Now, over there, the issue of maintainability had been urged. This is the third round of section 9 application where the jurisdiction issue is still pending. This honorable court, in exercise of the powers under Article 227, had admitted it, and the matter was being heard, and it has been heard at length at my learned friend's presence, and the matter is pending. The matter thereafter, the determination had changed. We had mentioned the matter. We are hopeful that the matter would be taken up very soon. I'm carrying the orders passed in the revisional application, my lord, if your lordship is pleased to take up. But otherwise, my lord, the issue of jurisdiction still remains. And now, my lord,
let that issue be resolved first, then we'll.
But that issue has been resolved by the Rajarhat Commercial Court.
Perhaps not, because the challenge is pending.
The challenge they have filed civil revisional application is pending. They went there and there was no, they never asked for any order of stay of operation of.
Because it was being heard, my lord, it was at my learned friend's presence. Those orders have been
denying
passed.
this. I'm only saying that, Lord, kindly
That
come.
issue, that is the first hurdle.
Kindly,
That has to
I'm
be
not,
decided and then
I'm
only
not urging on that. I'm only saying kindly page 77 of my application is a prior order passed by the division bench of this honorable court in section 9 application
And we are
itself.
complying with that order, my lord. We are making payment in terms of that particular order.
Very well, but only I'm only saying that in that order it is recorded that they had agreed to pay particular sum under the terms of this court's order. Now, if that be so, once they agree to act in terms of the orders passed by this honorable court under section 9.
So that is why you are saying that you have to resolve.
But I'm actually saying that kindly enhance the amount. Whatever they are paying in 2016, it's been 10 years. The market price has gone to a different level altogether, and they are now earning more and paying me less from my very property when there is a decree of eviction against them. 34 at that point of time, the law as it was, 34 on mere filing, they would have got a stay, and they got a stay. They never got it hard for 15 years. 2009,
There have been
2025.
a series of
not a
demurrer
single-
applications which had been filed by my learned friend.
Only
Well, there were
once.
2 applications which had
Only,
been filed. The
kindly, my
matter
lord,
had
I did
thereafter
not
been
interrupt.
transferred.
I did not interrupt.
Might not.
So,
But
that in 2010, when they filed it, till 2025, there is not even a single demurrer application. Then I filed one because of Commercial Courts Act. I won. The matter came to Commercial Court Rajarhat. Again, they took the point of jurisdiction and they again lost. Now that I am before your lordship, only saying enhancement of the same amount which this honorable court has passed. This is the application. This prayer of this application is limited to this. I'm not seeking anything. I'm not asking them to leave.
When is the revision likely to be taken up?
They're not mentioned at all after
we have
that hearing.
mentioned. We have mentioned. Perhaps my learned friend
This
is
has been received by me.
my learned friend is not aware of it. We had mentioned, my lord.
Don't give notice. I'm
What
not
had
aware of
happened was, my lord, Justice Shorkar had been pleased to. She's not taking up hearing matters at this because this matter needs to be heard. There is a jurisdictional issue involved. She has indicated that, my lord, it will be taken up soon. Now, my lord, that soon, perhaps I wouldn't be able to say, but nonetheless, my lord, we have mentioned the matter. We will mention it once again because I would definitely indicate, my lord, that this matter is pending and it has once again appeared, my lord, suddenly. I believe my learned advocate on record was not there in town. My learned friend's advocate on record has served a notice. I'm not disputing that, but this matter had appeared after a long hiatus. Whether the issue of jurisdiction would be there in the event this honorable court, my lord, exercises jurisdiction in terms of section 9, my lord, the difficulty would be in the event I succeed in the revisional application.
Section 9 applications. What about the arbitration?
Well, I won. Arbitration I won. They filed 34. Never get it heard for
unilateral appointment, my lord.
So
in my absence,
they had
that
the
is
chance.
The point. That
They
is
had
my
the
chance. That is my chance.
They
for
had the
section
chance. They did
34
not
application.
contest it. It was not that notice was not issued. And that point, and
That
in
cannot be the
2010, this
ground,
law
my
was
lord,
not
for an
there.
illegal void.
I do not know why this submission being made again and again before every court and they don't succeed. The arbitration award at that point of time, the question of unilateral appointment, that law was not there.
So your execution is pending.
The issue is not pending. That 34 they filed, that is transferred. I won.
No, they have not preferred
Rajahat
any
Commercial
execution
Court
application. No.
Rajahat Commercial Court has transferred the
I'm
proceeding.
asking, did you file execution?
No, I cannot. 34, they file 34.
There
and
can be a
under
stay,
the
my
old
lord.
law, as long as 34 is pending, I can't file section execution proceeding.
Perhaps that is not
My,
correct.
under the old act, 30 execution, I can only file.
Execution can be stayed, but
I can only file execution, and after dismissal of 34 is automatic stay on execution under the old law.
In the old act.
So, if that is there, I can't take that chance. So I am under section 9.
Wait for the outcome of the revision.
Kindly, if some preference is being given, or that order is passed, recording that this development is there, I can at least go back to that court and show that I'm bleeding every day. 4 rupees to me, 20 rupees they're earning from my property.
Perhaps my
Kindly, I have
is
given
making
calculation.
conjectures, my
I
lord.
have
Perhaps
given
submissions made from the bar.
I have given
I
calculation in
would
the petition
indicate. I
itself.
would indicate if needed.
This is not a submission from bar. I have given the calculation in my body of the
I would
application
indicate that,
itself.
my lord.
The same property they are exploiting commercially at a different rate and paying me in 2016's rate. Kindly appreciate that. I'm only asking you that if something can be recorded, I can go and show to the divisional court and request for an early hearing. Because otherwise, I will never be able to make profit from my own property. Kindly see my prayers were very innocuous prayers. I'm only saying that enhancement of the same sum which you are already paying me, you agreed to pay under the orders of this court. Page 77.
I'm paying, my lord.
Page 78 records their agreement. Before the division bench, they did not take this point of jurisdiction at all.
That jurisdiction point was kept open by the honorable division bench to be argued and adjudicated upon by the learned trial court.
Kindly, division bench order.
Section 34 court was to
77
take
division may kindly read.
cognizance of that.
Lordship permits me.
Both of your cards.
I'm so
speak at
sorry.
the
I'm
same
so sorry.
I apologize. Page 77 does not record any such issue. But page 77, I am placing it before your lordship that whatever my learned friend has said, that jurisdiction point kept open and all. The only thing recorded in this order, page 78, last paragraph regarding this is 34 proceeding pending before a wrong forum. An application made by the appellant herein is such forum for the return of disposal of the 34 should be dealt with by the court without undue delay. And I won this proceeding. 34 has been transferred to commercial court. Thereafter, I again filed an application for further transfer. That also I won. They did not take any steps thereafter. And otherwise, the jurisdictional issue which my learned friend sought to argue has been kept open by the division bench order is absent. That observation is not there. Instead, their agreement is recorded page 78, third paragraph. It is recorded that the respondent has also agreed to pay arrears due to the same rate amounting to rupees 42 lakhs. They agreed to act under the orders of this court in section 9. Now they say that they no longer will follow the same jurisdiction. After agreeing, an agreement is recorded, the jurisdiction is not even argued at that stage. I was there, my learned senior friend was not there in that stage, because I was there. They did not even take this point. I'm still not saying that I'm not requesting your lordship to
make my submissions once my learned
just
friend
one more
is through.
sentence, I'm not requesting your lordship to make that civil revision application infructuous by passing any order today on merits. I'm only saying, considering the nature of my case, kindly make some observations so that I can ask for an early hearing in the revision court. That's the only prayer to do. I'm not saying that let them.
You're always at liberty to ask for that.
But whenever I say that, the revisional court says, inform this court that we are in session of the matter. That is what happens. Lordship knows. I don't want to make any further submission on that. Kindly, if lordship's one line would help me to make that submission in revision.
Because this issue had been pending, my lord. The coordinate bench
Every
had
court they
taken
lost,
due.
but they kept it pending.
My lord,
That's that.
if your lordship, if I open my submissions, my lord, then perhaps if I address your lordship on the issue of jurisdiction, then perhaps I would be able to convince your lordship with me. But my lord, nonetheless, the issue is pending before the revisional court. I need to have it argued out, my lord, over there. That is all that I'm seeking for, my lord, at this juncture. Otherwise, my lord, the issue of jurisdiction, I've also taken it in my opposition. That needs to be heard out.
Take down. The petitioner states that that the issue of jurisdiction, which has been decided by the Rajarhar court, while its order dated 13/12/2024, has been challenged in a revision petition, which is pending adjudication. Full stop. Learned counsel for the petitioner states that this court, wide order dated, which is that order by which the amount has been fixed.
Oh, that is at page.
That is my 12th of April 2017.
This court wide order dated 12th of
April 2017.
12th of April 2017 had fixed
various payments, including rupees 42391 per month.
Payment schedule.
42391 per month as occupational charges.
Had fixed some payment schedule for the respondents to be paid to the petitioner.
And my lord, an ad hoc sum of 42 lakhs.
Learned counsel for the respondent states that he has been complying with the said order. Full stop. Learned counsel for the petitioner states that there has been material enhancement and the said payment was fixed in the year 2017 and which needs further revision. The said fact is disputed by the counsel for the respondent. Full stop. Since the issue of jurisdiction is pending before the revisional court, let this matter be listed in the monthly list of January.
We'll try and do something about it.
Try and do something.
One more line.
At least I have
I am grateful. I am grateful.
I've indicated your difficulty.
Grateful.
Grateful. Let's kindly indulge this. Just one mistake on my part. Item number 7. The pleadings were already complete. By mistake, I had filed a different application opposition. The court officer has pointed it out. But can you record it in the order? I'm so grateful. Man. Sorry for that.
Lord, this is, my lord, a section 9 application where pleadings are complete. And my lord, simultaneously arbitration has also been invoked. My lord, the 21 notice has been replied to, my lord. We are in process of preferring an application for, my lord, appointment of an arbitrator.
We have taken some jurisdictional points, my lord, because the matter is proceeding before the DRT surfacey notice. Now, my lord, which act will prevail? This is a pure question of law, my lord. I have a senior, my lord, above me.
Lord, Mr. Jointo Mitros, my lord, appearing, my lord.
So, Mr. Mitra has requested 15th, if we can have it. But we are yet to sit with him. The week starting 15th, any day if convenient to your lordship. It seems I come and trouble your lordship with the jurisdictional point more.
No, no, my lord, here, my lord, I'm optimistic, my lord, law perhaps has been laid down, my lord, subject to, my lord, what, of course, Mr. Mitra and Mr. Sen argue.
Mr. Sen will come up with something. So then we'll have it after 15th.
After 15th,
My lord, we were only hoping, my lord, before the vacation.
Yes, 15th we are.
Because reason being, my lord, that DRT has directed status quo.
Yes, so you are protected.
But we have filed an application for withdrawing the SARFAESI case because, my lord, SARFAESI notice was issued upon a dead person. They concealed the fact that their ancestor who taken the money had passed away. So on that technical point, the DRT stayed, my lord, the SARFAESI proceeding, and, my lord, the order of, my lord, the magistrate appointed.
You have 2 weeks. You can start the arbitration proceedings too.
No, my lord, we are in.
Filed a section 11.
No, my lord, we are in process, my lord.
Section 9 is pending since when? 2024.
This whole section 9 business has to stop.
Yes.
This has to stop.
And that protection is there.
Section 9 is an interim measure. All your disputes have to be.
And you'll take the injunction and you'll continue with the injunction. And
No, my lord,
But that's the whole idea of section 9, which is absolutely unfair.
Yes.
That's not
that's what
the
is
intent of the legislature to have section 9. 24 petition. There should be.
No, let us satisfy lordship on any day, my lord.
Satisfy on what? You file
Section 9.
Before-
You have to file a section 11.
No, of course, my lord. My lord, hope.
So after 2 weeks, we'll see that you have filed a section 11.
Yes, my lord.
Take all your issues before the arbitrator, not before me.
My lord, but we may, my lord, just require some protection because, my lord, our withdrawal, we have ourselves, my lord, applied for, my lord, withdrawal of the DRT proceeding. If, my lord, that is withdrawn, if that is,
Go before the arbitrator, he'll give you the protection.
my lord, we are in process, my lord. Kindly, my lord, keep it, my lord, on any.
The interim applications before 17 applications should be filed there.
Yes.
Or I'll treat this as I'll send it before the arbitrator.
But first, let
You have to file a section. Yes, you have to file
11.
My lord, kindly keep it, my lord, anytime, my lord, in December. That's my only request. My lord, I will also, my lord, have a
At the
leader
request
in the
of the
matter.
parties, let this matter be listed on 16th of December.
Yes.
No difficulty.
But Mr. Lakhwani, before that you file your application.
My lord,
I don't want these matters to be hanging in here.
understandable, my lord. Understandable.
All these section 9, and that is the reason you see all this coming up. Because I'm getting all this listed.
Yes. Section 9.
Section 9 has to go.
My lord, can it be 15th or 17th, subject to your lordship's convenience?
17.
17th.
These have to go.
Grateful, my lord.
Go before the arbitrator.
No, my lord, inevitably we will.
You
We
have
were
to.
only hopeful, my lord, that until the arbitrator takes over, my lord, there could be some protection.
Protection from the arbitrator. I don't subscribe to this view of section 9.
Lord, in the facts of this case, perhaps we'll try and convince your lordship, my lord.
I'm not saying anything, but I'm just
Given an offer to settle for 33 crores, which we've refused. That's, my lord, that's what, my lord, I didn't want to say it out loud, but, my lord, it's.
I know settlement, Mr. Sen.
But I have no instruction. This is a Delhi based.
They have offered a pittance, my lord. That's the reason.
I'll take instruction, but.
Arbitration and argue, we can take it at any time.
Grateful.
But he has to go to arbitration to settle.
Grateful for that.
But this is a section 9 application. I had made extensive arguments before Justice Sarkar. They were supposed to give reply, so I have to start all over again.
But the order sheet doesn't show that.
Yes, I had finished my submissions. These are the notes.
And Mr. Bostis is.
I remember. No, but not parted. No, not parted. I mean, if that's no, it's not parted. But I had made. I said it's laying the submissions.
You have to make that effort once again.
Now, my lord.
Yes.
Now, my lord, there are three agreements. My lord, the dues of Srei are about 1,200 crores. Against this company, my lord, Tuticorin. My lord, now what assets Tuticorin has? Basically, I don't know. It does nothing, my lord. I have not been able to trace. Now, my lord, let me tell you the facts of this case, because they are disputing, my lord, the arbitration agreement itself.
Though the matter has been heard, it records that the hearing will continue. The hearing will continue.
Yes. So it is continuing. Now, my lord,
yes. Yes.
Yes. May I?
No, I was just indicating if both the parties say, then probably I can record that. I can send it to.
No, my lord, equally heavy bench.
Equally heavy.
Equally heavy bench. You can logic and send it, but it will equally heavy. We are someone has to, but it will take some time, no doubt. Not like the other one. There also.
Shall we have it?
Entirely for your lordship. Second half. Not today. I mean, my lord is suggesting that.
Then we'll have.
Entirely for you. I'm ready to do it.
No, if this takes time, because I've got a matter fixed at 12:30, which
acha. Then
which I want to finish.
No, but it won't finish by 12:30. This much I can tell your lordship.
Then when do you want it? After
It's
vacation?
It's your lordship's convenience first.
After vacation?
My lord, it's for your lordship's convenience. I cannot impose impose a date. My lord, any date which your lordship will fix. My lord, this is also section 9. It has to be, I believe, section 11 pending. My advocate on record is not here. I believe there is also.
There's section 11 already filed.
Probably. I was told when the matter started, 2 juniors have disappeared, and the advocate on record also disappeared.
Then we'll have it in January, Mr. Boss.
Then my mails could be after the 11th month.
We'll have it in the monthly list of January then.
This one would be the 4th month. That is why I'm a bit concerned.
No, it won't be. Come on, there's so many matters.
If I'm not there,
That's not. Sure. At the request of the parties, let this matter be listed in the monthly list of January. Monthly list, January.
This section in application, my lord. On the last occasion, it was written in June 13, my lord. There was a direction for service on the respondent, my lord.
What about arbitration invoked?
My lord, I am not aware of the fact, my lord, the advocate report is.
Applications, you have to.
My lord, kindly gives us a short interim order, my lord. Thereafter, I'll take instruction from the client to file, to take steps to go for arbitration, my lord. They have refused. They refused the service, my lord. My lord, in this similar type of matter, my lord, the injunction was granted, my lord. I have the order also, my lord. If my lord pleases, I can show the order, my lord. Similar type of matter. Injunction be granted for limited period, my lord. Within that period, we'll file the.
13 June, the court is indicating that you should invoke the arbitration proceedings.
Yes, my lord. My lord, I don't have instruction right away, my lord. Kindly give dispose it of with an instruction that within 3 months we'll take steps to go to arbitration, my lord. If my lord please, my lord.
You're seeking attachment of the
Yes, my lord.
attachment of
Attachment of the bank bank account, my lord, at page number 7, my lord, paragraph 18.
they have never appeared.
They have refused, my lord. They have never appeared, my lord. It's written that they have refused. At the back of the envelope, my lord. 3. The binding is a little difficult, my lord. So it's inside. Yes.
There are 3 respondents.
Yes, my lord.
You're seeking attachment of
Bank account, my lord, at paragraph
of which
of respondent number 1, my lord.
take down despite service. None appears for the respondent. This court, while order dated 13 June 2025, had granted an opportunity to the respondent to file their affidavit of asset. It also further observed that the order of attachment was not being passed since the court was inclined to give an opportunity to the respondent before passing any order of injunction. Full stop. It is noted that despite service, it is noted that the respondents have refused service, which is deemed to be good service. Full stop. They have chosen not to appear before this court. Full stop. In It is the case of the petitioner that he had advanced a credit facility to the respondent. The respondent failed to repay. When is the loan recall notice?
Yes, my lord, page. And well, the page number is not there. It's annexed there in the petition. The page number.
The
Page number.
The loan recall notice was issued.
It's there.
Full stop.
It's there.
The loan was terminated.
Dated.
Full stop. Since when did he started defaulting?
My lord, they started defaulting in February, from February, my lord, as recorded in.
Which payment? Which schedule?
Yes, the schedule is there, my lord.
The petition relies upon the arbitration clause contained in the loan agreement and the jurisdictional clause to assert that this court has jurisdiction to entertain this application. Full stop. Jurisdiction to entertain this application. It is full stop. It is contended that part of the cause of action arose within the jurisdiction of this court, comma, in as much as, comma, the loan recall notice was issued and the termination of the agreement was caused from the office situated within the ordinary original jurisdiction of this court. Under such circumstances, comma, a prima facie case for securing the amount has been made out, comma, although the loan is an unsecured one. Full stop. The fact that the respondent is not before this court despite notice, comma, indicates that there is a likelihood that the respondent might siphon off the money lying in the bank account. Full stop. The details of the bank account are set below a page 7, para 18. Set below under such circumstances, comma, page 7, para 18, bank detail ledger. Under such circumstances, comma, the respondent is restrained from operating the above bank account, comma, without keeping aside a sum of rupees. How much is the amount? 17 lakh?
17 lakh 37,730, my lord.
17 lakh so and so. Okay. 17 lakh 37,730. Full stop. This is not the final adjudication of the claim. Full stop. The concerned bank will comply with this order on the basis of the server copy of the same, comma, which shall be served by the petitioner or its learned advocate on record. Full stop. The operation of the bank account shall not be allowed unless the respondent maintains a sum of rupees 17 lakh 37,000 so and so in the same. The respondent is granted liberty to pray for variation, comma, modification or vacation of the interim order. Full stop. The interim order will continue for a period of 2 months.
2 months, my lord.
2 months from date. Fresh. To serve them again.
We'll serve them, my lord, and take
Fresh
steps
service
for
of
arbitration.
will be issued upon the respondent. Affidavit of service shall be filed by the next date. Let this matter appear in the monthly list of February.
Much obliged.
25. In the meantime, the petitioner is directed to take immediate steps for appointment of the arbitrator in terms of the arbitration clause.
Grateful, my lord.
Need to file the affidavit in opposition served in August.
Served in August. Arbitration invoked, not invoked.
Invoked, my lord, the section 11 application.
When?
My lord, the section 11 application is pending before this court, before Justice Shampa Sharkar. It's listed today, item 43, for orders. It shall be taken up tomorrow, my lord. section 11. The only thing is,
everything can
in,
be
yes, my lord.
sent to the
The only thing is section 9, the
No, I've
interim
got
order has
130 crores locked up, my lord. I want
the
a
interim order
disposal.
has expired yesterday, my lord. I was
Yes, no,
only
I
thinking if a
want a-
limited extension could be granted, we shall
That, August have served
abide
him
by
in
the-
opposition. He doesn't file a reply from August. We have just entered December, and he wants an interim order extension. My lord, I can't be, my lord, unreal. I can't, my lord, say that just for this reason, don't permit him to have an extension. What I'm submitting is that this is the matter which doesn't really require affidavits. If at any point of time your lordship feels that an affidavit in reply is required, please extend the interim order and give him the chance. But let my learned friend start. There's nothing in it. Well, I am saying that he filed a section 9 application. He did not get an interim order. During the pendency, when the bench changed, he filed another section 9 application. We took the point that this is, my lord, bench hunting and you can't do this. He then went and withdrew the first section 9 application without leave. So therefore, my lord, there is no fresh cause of action. He's not entitled, my lord, to any interim order. This is number one. Number two, there are two petitioners. He's invoked an arbitration agreement contained in an assignment agreement, which has, my lord, one lender. So therefore, the form is not correct. In its present form, it can never go to arbitration because there is no arbitration agreement amongst all the parties. Number three, my lord, there is a forum selection clause. This, I'm sorry, my lord, this is the agreement was entered into in Tiljala, which is outside High Court jurisdiction. And that's, my lord, very clear in the first petition. Argument on jurisdiction was happening. At this juncture, when he files the second petition, he includes a statement, which is an afterthought. Agreement was entered into opposite the High Court. Lord, in Kiran Shankar Roy Road, Shrey Milord is a big concern. Kiran Shankar Roy Road office is, Milord, a small room. So he says all his directors, all my directors, enter into 1,000 crore transaction, leave the main office, come in a car and enter a small 6 foot by 6 foot room and execute a document. This is, Milord, unreal. So this is, Milord, this is where things are. Milord, I had received 130 crores pursuant to an arbitration I had with NHAI. These are road building contracts. Now, setting aside was pending. NHAI, I won there. NHAI put in the money. Now that money, my lord, he's attached with this injunction order. So I have 130 crores. Even though the order has expired, we've kept the money. Now I request my learned friend to, my lord, argue the matter.
Yes, sir.
My lord, the points taken by my learned senior friend, these are all points which relate to the section 11 application, which is pending before this court. My lord, these points can be taken up before the arbitrator.
Lord, it's not the law that ad interim order will never be, my lord, thereafter
My lord, would
considered
just
at the
extend the
final
order till
hearing.
the outcome of the
So
section
then
11
you have
application.
it extended till award, then,
Till the
till
outcome of
setting
the section
aside.
11 application that is pending before this court.
Oh, also, my lord.
Is it listed for orders today?
It is listed for orders, but it will be taken up tomorrow.
But I think my learned friend has a senior. If my learned friend comes back, my lord, then
day after tomorrow.
Otherwise, he'll get after me, my lord, in bar library. His senior will come running after me.
When do you want?
The day after tomorrow, my lord,
Day
I'll
after
come
tomorrow.
and argue.
Let the
Yes,
interim
yes,
order
yes.
be extended, my lord.
Is it
It
But please
expired
extend it
yesterday,
a
my lord.
Short extension, otherwise he won't come back and argue.
Then let him file his reply also then.
Let him do it tomorrow. He's had time from August.
My lord grants us 1 week time.
1 week.
1 week.
Learned counsel for the petitioner seeks and is granted 1 week time to file his reply to the affidavit in opposition.
My lord.
Interim order granted earlier shall be extended further for a period of
That's why he has
2 weeks. 2 weeks.
My lord, your lordship is giving them till next week.
1
my lord.
week. 1 week.
I'll come immediately and argue it, my lord.
Further for 2 weeks, let this matter be listed on first. So we'll have it on the 9th or 10th.
Any day as per your lordship. Any day.
But they should not, my lord, come back and say arbitrators appointed,
because I'll agree to appointment of arbitrator. So I will not have the section 9 heard because I could have actually have it heard today.
But that's exactly what is going to happen.
Yes. So this is why, my lord, he is not filing his reply. But let him not take advantage because your lordship doesn't
happen.
Then I'll take an adjournment in the section 11.
My lord, my learned senior friend contested the section 11 application. Then he should have agreed to the appointment.
See, this has to go before the arbitrator.
But interim orders can be decided. I could have had it decided today.
See, what I can do is I can probably, interim order. I'm not going to vacate just like this. If it's going before the arbitrator, then the arbitrator will decide. I'll send the application.
My lord, to test the papers on the
Let's see if I can, my lord, stop the section 11 court from passing an order. Then I'll apply for vacating. Because I have a good point there. The petition.
Stop the.
Yes, but both petitioners are, my lord, not parties to the agreement. And he can't have, my lord, his invocation is wrong.
Still, that has to be adjudicated. At this stage, how will you? When do you want it?
We'll try.
When do you want?
Whenever my lord keeps it.
When do you want, Mr. Chaudhary?
Whenever, my
As
lord,
per
your
your
lordship.
lordship's
I know my fate quite clearly, but it is my job to try.
10th?
10th is fine, my lord. I'm extremely grateful. My lord has extended the interim order.
10th December. I'll get affidavit of
My lord has extended the interim order by 2 weeks, my lord. I'm grateful.
Next.
Krishna. Lord, your lordship be pleased to keep it, my lord, next week. Because I'm told, my lord, the clients are going to sit this week. Lord, they were supposed to sit last Friday, but it didn't happen. I'm told it will happen for settlement. It's best for both of them. যদি হয়ে যায় খুব ভালো হয়
Mr. Mukherjee.
Yes, my lord. In fact, I was hoping, my lord, that we could file the terms of settlement here. Then we'll have a court order. They've approached us, my lord. My client wasn't available. My lord, he's back now.
All right.
But I don't know if 1 week will be enough time. That's the only thing I'm worried about.
2 weeks?
2 weeks.
So then in that case, January.
Very well.
Hardly have time.
Lord, may I say this, my lord? When matters in court, even my client will feel pressurized to go and settle. I'm not saying.
No, I'm saying that I'll
Please
just
let it appear after 10 days. Otherwise, not, we'll then take it to January. If it isn't done, we'll try and get it done.
at the request of the parties, since some settlement talks are underway, let this matter be listed on.
That's why we're coming back.
Then when do you want?
My lord,
After 2 weeks? After 2 weeks. So we'll have it on the 16th?
very well.
16th?
And may I file the affidavit in reply, my lord? Already served.
Affidavit in reply is there.
Thanks.
Great.
Lordship, this is my Section 9 application, Lordship. There was a direction upon the respondents to file their opposition, which has not been done.
I am told that the talk of settlement is going on.
Lordship, I also have been informed that there may be a settlement, Lordship. I have not got the official instructions, Lordship. If it could be kept after a week, I think I'll get the official instructions on this.
You want to file your affidavit in opposition?
It depends, because there is a talk of settlement is going on. If it is settled, there may not be any need for filing.
Learned counsel for the. No, then I have to record your affidavit in opposition whether you want to file it or not.
Then kindly keep it open.
Learned counsel for the respondent seeks and is granted further 2 weeks time to file his affidavit in opposition. Full stop. The parties state that settlement talks are underway and prays for an adjournment. Let this matter be listed on the 15th of December?
Yes.
15th December.
10th of 15th.
Because Lordship, this is my Section 9 application. Lordship, there is already an injunction on the bank accounts passed on 4th of August 2025. Lordship, we were directed to serve on the respondents, which I have done. Lordship, the Section 21 notice I'm said has gone on in the last week to the respondents. So, Lordship, if this injunction order could be kept subsistent till 1 month, we will go to the arbitrator because the arbitrator will be proceeding with further orders. Just they have received this order.
Affidavit of service taken on record. Learned counsel for the petitioner states that the respondents have been served. Full stop. Despite service, none appears for the respondent. Learned counsel for the petitioner further states that notice invoking arbitration has been sent on.
Lordship, I am not aware of the
has
date.
been sent. Full stop. She states that further steps will be taken for appointment of the arbitrator. Let this matter be listed in the monthly list of January.
Lordship. And Lordship, I'm really sorry for the stuff.
Your Lordship, I'm appearing for the petitioner. Your Lordship, Mrs. Shah was arguing this matter. Your Lordship, due to some difficulties, unable this.
Section 9 application. They're enjoying an interim order. In the meantime, tribunal has been formed. Section 11 filed or formed.
Appointment.
Yes, done. The tribunal's first date is in, I think, within a week's time. So the interim order, which is subsisting from 24th, 25th of June.
Yes.
So I cannot stand in the way because we have not preferred an appeal from this order. This order remains. The third page of the order from changing nature, character of the bungalow, encumbering or creating third-party interest. Page 3. So, if this continues, my lord.
Your Lordship, kindly keep this matter next week. Your Lordship.
We'll have it next week, Mr. Shah. Proxy counsel so and so appears. You're the are you the advocate on record, madam?
In opposition be kept with.
Affidavit in opposition filed by the respondent is taken on record. Mr. Mitra states that let this matter be listed on next week. We'll finish it off.
Yes, I know, but it has to go before the tribunal.
It's taken on record. Learned counsel for the petition. Proxy counsel for the petition states that the main arguing counsel is in some personal difficulty. She prays for a short adjournment. Let this matter be listed next week.
Much obliged.
Next.
"27 is my application under Section 9, Your Lordship. I was to file the affidavit in reply to the opposition. I have already served the copy of the reply. May I file the affidavit in reply in court, Your Lordship?"
What about the constitution of the arbitral tribunal?
We have already invoked the arbitration. Section 11, what is the status? It is in the process of being filed, the Section 11. It will be filed peremptorily.
Yeah, Section 11,
I am also, my lord, opposing this because, my lord, there is a Section 7, my lord, already pending before NCLT, my lord, on the same issues.
That is not perhaps the jurisdictions and the issues are distinct and separate.
And on the first
I will make my
instance,
submissions on that.
the interim order, my lord, was rejected, my lord, because
Ad interim order was not
on
granted. It
19th
has been
of
set.
August, there is already, my lord, an order, and the court found, my lord, kindly, my lord, takes the order. 11, of course, that's not before your lordship, my lord. I will not. Kindly see the order of 19th August 25.
Ad interim has been rejected, so Without affidavits upon affidavits also it should be rejected. Auditor to Marco. The order is it has to be heard upon affidavits because significant issues of facts are involved.
Court said, my lord, they want stay on 2 notices. Staying that would mean, my lord, deciding
The issue has to be decided upon affidavits at page 3. Moreover, if the termination is found to be invalid, petitioner can be compensated.
You have filed your affidavit in opposition?
Yes, I have filed the reply. Is it your lordship's pleasure to take it up on any day, tomorrow, day after? It'll take some time.
Not this side.
Very well, as it commends to your lordship.
At the request of the parties, let this matter be.
Subject to your lordship's diary, my lord. After the 6th, if possible, then, my lord.
After 6. It will be after 6. Affidavit in reply filed by the
6
petitioner is taken on record.
6 January.
After
After 6 January.
At the request of the parties, let this matter be listed in the monthly list of January.
Deeply obliged.
Grateful. Deeply obliged.
Yeah, madam, your affidavit of opposition.
Original affidavit of opposition?
It was served, but I don't know
No, I
if
don't
it
have
has
it.
been
It's
filed.
not there in the file. That's what my court staff is just pointing out. Where's the affidavit in opposition? Give a copy of that. We don't have it. No.
So technically it has not
My
been
lord,
filed.
I'll ensure, my lord, it's given
Very
to your
well.
lordship.
It often happens in original side.
Just check.
My lord, we'll hand it over to your lordship's court office.
I'm deeply obliged, your lordship.
Yeah. Gopal? I'll be back in Shall we start?
Mr. Lord, before my learned senior friend begins, my lord, on the last occasion, my lord, there was talk of the additional documents. My lord, we haven't been provided a copy of the additional documents. So, my lord, may I pray?
I thought it was already there because arbitrator has given to both the parties.
My lord, on the last occasion, I made a submission that we do not have a copy.
I will make it over.
Yes, my lord, my learned friend may make submissions, my lord. I may be handed a copy of those additional documents.
Yes, yes. But I was on the award.
Yes.
Primarily, the challenge, my lord, is restricted, my lord, to the claim for damages. And why? Because it is settled that damages has to be assessed on the date of breach. So, my lord, the consideration is what is the date of breach under the contract. My lord, the law is also this that, my lord, today there is a breach. Yes. This position, the arbitrator accepts that it has to be assessed on the date of breach. But thereafter, my lord, if your lordship comes to 177, this part, my lord, I think is completely perverse. Perverse in the sense I do not challenge it in that way. I say that it is absolutely contrary to the settled principles. It's a rather word, but the expression should be patently illegal in terms of the Sangyong judgment. Now, my lord. Kindly see 177, last paragraph. There is no dispute to the settled position of law that in normal cases, any dispute between the private parties, loss has to be assessed on the date of breach or soon thereafter. But I don't think it can be qualified as between private parties. In a contractual dispute, this is the law. It does not matter that government is a government company is one of the contracting party, because a government company is not treated on a different pedestal in a contractual dispute. Every party is the same, law of contract will apply, because it is not a 226 jurisdiction. I am not challenging the action of the government as it is capricious or arbitrary. I am saying it is not in accordance with the contract. So, my lord, this should be qualified as in normal cases, any dispute, loss has to be assessed on the date of breach or soon thereafter. Well, thereafter, your lordship will find. However, this is a case between a statutory authority whose entire action must be reasonable. This part, I think, well, is going beyond the ambit of contractual adjudication. JCI on the date of breach could not be in a position to sell the jute in the open market. But this is completely dehodes evidence and the pleadings of the parties. I will show your lordship, my lord, their statement of defense and the contractual clause. They had to take step by public advertisement or other established procedure to try to sell the jute, which naturally will require such reasonable time. This is also not their case, that ultimately a public advertisement after the process and public advertisement was issued on such and such date. So this is some bit of a presumption coming in.
Yes.
Moreover, JCI has also the duty to take steps to eliminate the loss, as it is not only the settled position of law, but it is their duty as public authority to try to eliminate the absolutely correct, Malad. It's the principle of mitigation of damage. It could be seen that price of jute which had fallen would rise again. Kindly say, this is the point, Malad, I would like to harp, that you cannot make a windfall out of your claim for damage. Then now I will show your lordship one letter of mine where I had told them that today there is no market loss. I am coming out of the contract voluntarily. Why? You will not be at a loss today. So that I had tried to say. There is no evidence that on that date that the price of jute had either fallen or so that it would be a loss for them. But here they say that it is prudent for the statutory authority to wait, so that if I wait for certain time, then I will make a profit. That is not the principle, my lord. Moreover, since the jute mills had no right to cancel the contract, they could suddenly claim to purchase the jute had the price risen. It was, however, not permissible for JCI to wait indefinitely and suddenly come and claim the loss. In view of the above, I hold that about 4 months' time should be held reasonable to enable the JCI to sell the jute after cancelling the contract. But this is my challenge primarily. Why should the arbitrator on its own give them 4 months' time to enable them to get a higher price? Then they have said, JCI has not yet sold the jute which is still lying in their godown and as such incurred a lot of expenditure on the ground of storage. But this is their fault. Why did they not sell it? Now, my lord, kindly let me stick up to here, and my lord, I'll show your lordship from the document. Now, first document which I show your lordship is, yes, contracted again. Yes, the contract, my lord, a particular clause, my lord. Yes. Kindly come to page 41. ঠিকটাই তো equivalent. Yes. সেটা এখানেও আছে. Kindly come to, I will come to that. Kindly come to clause 6, my lord.
Payment terms.
Yes, payment terms. Buyer has to furnish payment arrangement through confirmed irrevocable letter of credit and or bank draft pay order, preferably through nationalized bank, covering 15%. Then, my lord, valid LC should be furnished within 5 working days from the date of commencement of the contract or 10 working days from the date of issuance of the offer. Then, my lord, kindly come to 6.3 and 6.4. Delay in submission of LC with carrying charges, etc. shall be allowed for maximum period of 30 days from the date of issuance of the offer. 6.4. In the event of the failure of the buyer to deposit LC within 30 days from the date of issuance of the offer, the contract shall stand revoked and the security deposit shall be forfeited. So, my lord, this is automatic cancellation of the contract if no LC is deposited within 30 days from the date of issuance of the offer.
Yes.
Kindly come to read this clause along with 4.7 at page 40. JCI reserves the right to recover carrying charges and other incidental charges, that is interest, go down charges, taxes, etc. at the rate of 2% of the contracted value or 25% per quintal per month, whichever is higher, from the security deposit in the event of the failure of the buyer to lift the contracted amount of jute within 30 days from the date of submission of LC. JCI reserves the right to forfeit the entire amount of security deposit in the event of the buyer failing to lift the entire contracted amount of jute within 60 days from the date of submission of the LC. So, there are two situations. One is I do not deposit LC within 30 days from the date of the offer. And then I do not lift within 60 days from the date of submission of LC. This is to be read with clause 12, their right of termination. In the event of any delay or failure on the part of the buyer in making payment arrangement as specified within 30 days from the commencement of contract and or refusal to take delivery of the contracted quantity within a period of 60 days or to perform any of the terms shall have the right to exercise any of the options, including cancellation of the contract. So cancellation of the contract either 30 days from the date of the commencement of contract or 60 days from the date of refusal to take delivery. Now kindly see, kindly note the date, my lord. Date of the contract is 8th September 2006. That is page 38.
What is the date?
8th September 2006 at page 38. That is the date of the contract. Now kindly see, again 60 days কবে থেকে ধরছি আমি? 8 September. Yes. So my lord, that period of 60 days under the contract, 60 days will be expiring on 8th October 2006. 8th November. September? Yes, 8th November. I'm sorry. It is not October. 8th November 2006. So, my lord, if I have not fulfilled my obligation within that period, I am in breach. The contract should be revocable on that event. Yes. After this date of 8th November, I myself am giving this letter to them. Kindly see page 60. The 60 days. This is after the expiry of that period. 12 days. Yes, I am saying kindly see, I am very candid in this. Please be informed that due to financial crunch, we will not be able to make any further payments against the above contracts. And as such, balance quantity may be treated as cancelled without any market difference. Why I am saying this? I am saying this that I am aware of the breach has occurred. At this stage, if it is mutually cancelled, then there will be no market difference. Whatever contracted price, this contracted price is available and you are in a position to recover the same contracted price. This is the position which I am making them clear of this. Then I am saying, we find that there remains some balance of 35 lakhs paid to you and adjusting the deliveries made by you recently. So you already have 35 lakhs. You have already delivered some amount out of that. Whatever is left out of that 35 lakhs, it can be delivered. This is my position. As such, you are requested to deliver the balance quantity in any of our mills against the balance remaining with you out of 35 lakhs already paid to you. So this is my, what should I say? This is a right exercised by me so that the contract can be mutually come to an end without any loss being caused to the other side, my lord. So now the question is, kindly come to the reply of this letter. Page 52. Kindly see, they wait for a period of almost 8 months. And arbitrator কতদিন দিয়েছিল? 4 মাস. 4 মাস. Here, my lord, they have given, kindly see non-compliant, June 25. This is, my lord, very important. But it is also very significant why in the month of June a reply is coming for the first time. This is the period when new jute comes and the price is at a low in June. Now, my lord, kindly see, if your lordship says different mills are concerned, Premium Agro, we are concerned with the fourth one, Premium Agro, in this matter. Second one also. And the other matter, the second one, but kindly see, they are saying they have already delivered 448. Balance quantity was 3152. We have time to time requested you to arrange for necessary payment arrangement and take delivery of the balance quantity of the contract, but you failed to make payment arrangement for lifting of raw jute as per contract terms. You have further requested via your letter dated 22nd November to cancel the balance quantity as you are unable to make payment arrangement due to your financial crunch, which is not acceptable to us. Accepted, my lord. It is not acceptable. So on that date, you calculate your loss. If it is not, if it is calculated on that date, whether you would have suffered a loss, I would have been liable to pay. This is the issue. You cannot say that I will calculate my loss at a time when the price has already fallen. That is amounting to making a windfall. So, my lord, this is the point, my lord, which I want to harp, and my lord, this point has not been considered by the learned arbitrator, my lord. There was a jute mill strike because the contract stood repudiated by breach. That is the clause of the contract. If I am at fault, I will be liable to pay on that date whatever loss you have suffered. So, my lord, this is the only issue, my lord, which will be concerning. Now, let me show you, lordship, before I go to the other letter. Now, my lord, kindly come to the termination, which is at page 61. No, 60 হচ্ছে আমাদের. 61 is there.
4th July. 4th July.
Yes. Kindly see 61.
Yes.
We are in receipt of your letter dated 25th of June. That is the page 52, which I had placed. And surprised to note that you are still showing balance quantity of 37,000 against your so-called contracts. 5 mills. In this connection, we refer our letter dated 13 November, where we have requested you to send a sample quantity against our advance payment of 35 lakhs. And it was also mentioned in the said letter, if the quality is approved, then we may negotiate for the entire quantity of so-called FS5 and FS6. Now, my lord, kindly note, next paragraph, we are also refer our letter dated 22nd November. That is the page 60. Wherein we have categorically said that due to certain unavoidable circumstances, we are not in a position to take any further quantity. We have also mentioned that the contract sent to us and accepted and signed inadvertently may please be treated as cancelled, and there was no price difference as on 22nd November 2006. Thus, we requested you to cancel the balance quantity without market difference. It is very surprising to know that there was no correspondence on this issue since our last letter of 22nd November. All of a sudden, after 6 months, you have raised this issue via your letter dated 25th June 2007. Please note that it is a closed matter. We are not at all liable. Malad, why then, Malad, why should I not take it that my stand of November 22, 2006 was accepted? This letter at page 52 comes as a total bolt from the blue after 8 months, and so long from November you have been keeping quiet, saying, knowing that there is no question of any loss being suffered by you. This is the point, my lord, which I feel that the arbitrator has not considered at all. Now, kindly take, my lord, the statement of defense once.
Page 90 থেকে শুরু।
Dukhana statement of claim? Oh, I'm sorry. Yes. My lord, kindly see the statement of claim, then I'm coming to the statement of defense. Yes, filed by them.
65.
Yes, starts at 65, straight away kindly come to, they have quoted the clauses. Yes. Paragraph 11, 12. Respondent had taken delivery of raw jute equivalent to rupees such and such. JCI adjusted the said sum against aforesaid deposit of 35 lakhs. Subsequently, JCI asked respondent to take delivery of balance quantity of jute by making payment. Respondents, instead of taking delivery of raw jute, terminated the contract on the ground. This is actually not a case of termination. It is not a case of repudiation by breach which is accepted by me. Now, kindly see paragraph 16.
Obligation to deliver 1800.
Yes, according to the said contract, respondent was under an obligation to take delivery of 1800 at the price indicated. Out of the said 1800, they had taken delivery and they have failed and are neglected to take delivery of balanced quantity of jute, causing financial loss. But the point remains, my lord, they have not mentioned that 60 days period had already expired. There was already a breach, and by reason of the breach, I had surrendered. This is the issue which is not here. They are trying to take advantage. They cannot ignore the contractual clause. It is their contract. So when they plead all this, they are trying to make a case as if the contract was alive for all times to come, and it's only because I did not take delivery. My case is otherwise. My case is 60 days expired on 8th November. Immediately I point out to them that it is not possible. The contract should be closed because on this date you do not suffer any loss. They have to prove that even as on that date, the price was lower than the contracted price, and had they sold in the open market, they would have suffered loss. Then the difference they can claim by way of damages. What they have made out here is, kindly see, I have placed 16. Then kindly see 18 and 19. Although as per the contract, respondent was under an obligation to take delivery upon making payment, arrangement of raw jute within the time mentioned in the contract. What is that time? 60 days. They failed and neglected to lift the same within the stipulated time. So once they refer to the contract, it is that 60-day period. Now 19 is a departure. 19 they say, in the meantime, due to recession in the jute market, prices of raw jute according to JBA quotation decreased from 1340 as on 7th September 2006 per quintal to 1140 per quintal as on 22nd January 2008. This is the, my lord, windfall they are trying to make. So the entire case is based on the fact that in 2008, because I have come to know that the prices have fallen, I am now going to, my lord, claim my damages as on that date. The arbitrator, my lord, fortunately for my client, accepts the legal position that these damages ought to be assessed as on November 2006, when the contract stood repudiated by breach. And both parties are ad idem. I have not asked for any extension. That give me extension of the period. I did not want to keep the contract alive. So that they cannot take the point that the contract period is contract still continues by conduct of parties. So under paragraph 18, once they make the pleading in paragraph 18, they have to stick to the 60-day period is the time for performance. And that time for performance has failed after a lapse of 60 days. So, my lord, this is the issue where, my lord, the arbitrator has actually expanded the scope of section 73, gone beyond the provisions of section 73 of the contract. Yes. Now kindly see their claim at paragraph 21, paragraph 22. At the material point of time, JBA quotation price of TD5 ex West Bengal was 1340, but on and from 7th September 2006, the price has fallen to on and from 7th September 2006, the price has fallen to. This is not the evidence, because paragraph 19 says it has fallen to 1140 as on 22nd January 2008. 7th September, it was 1340.
How much was it?
Kindly see paragraph 19. They say it had fallen from 1340 to 1140 on 22nd January 2008. Paragraph 19.
Contradictory to 21.
Yes, is absolutely contradictory to 21. But I think this is somewhat a because this is carrying costs they are claiming from 9th October 2006. That is a separate thing that I will come later. But the differential in the contract price, that is as on 2008 quotation they have given. ওদের section 21 নোটিশটা দেখি।
And that would have explained it. 21 notice, where is it?
Yes, I am just
Not a next.
I'll just show their demand notice. What does it say? Termination notice to bar kar. Yes.
Advocates.
Yes, kindly see their advocates notice. At page 53, but here it starts at page 53.
Yes, an extra day.
Yes. At page 55, kindly see at page 55 top. I'm not placing the entire thing. Aforesaid contract authorize our client to terminate the contract if you fail and neglect to comply with the terms and conditions. But there is no clause authorizing you to terminate. Unilateral termination by letter dated 22nd November on the grounds is contrary to the terms and conditions that I have made. Our client by writing dated such and such is required to take delivery of balance contractual quantity after making payment for the same. Otherwise, necessary action would be taken. 6.4. We have been instructed by our client to call upon you to take delivery of balance quantity of JCI by paying the value of the same at a contractual price within 15 days. So they cannot keep the contract alive like this. Unilateral, just as unilateral termination, unilateral extension is also not permissible. I have not sought extension. You cannot say that I am keeping the contract alive for you, and the contract will continue to survive. That the seller cannot say. Seller is bound by, unless I say extend the time of delivery. You are free to accede to my offer and extend the time for delivery, reserving a right to you to claim damages. That is permissible. Here is a case where the contract stands repudiated by breach. You are saying that I am still giving you time. Then, my lord, kindly see they. Now, in this regard, kindly come to my defense. My statement of defense, my lord, starts at page 90. 31st November they have invoked arbitration. HET টা আছে কিনা দেখো। My lord, kindly come to paragraph there is a denial, but what I have said is, my lord, what is more important, I have dealt with their letter by which they are unilaterally extending the time. I am saying that the contract is already over.
Para 16.
Yes.
Offer was deemed to be withdrawn since the respondent not eligible.
Paragraph 16, last lines, my lord. Formally recorded refusal for the accept the offer also there in the event any surplus remained, you can draw due to surplus. The balance may be paid to SB Overseas. Then after lapse of 6 months, they have given that letter of 25th June that I have already placed. Then paragraph 18, they have replied. We have replied, and I have denied that there is no question of payment of any balance quantity and or lifting. My lord, important is paragraph 23. Kindly come to paragraph 23 at page 100. Purported claim of the claimant is bad in law, arbitrary, not tenable, inasmuch as no damage or loss has been suffered by the claimant as wrongly claimed by it, as per their own admission. This is important. Price of raw jute sought to be allegedly contracted for as on 7 September was 1340 on the basis of rates quoted by Jute Balers Association. Price of self-same raw jute as on 22nd November 2006, as per quotation of Jute Balers Association, also 1340 per quintal. So there is no difference.
Which we wrote in the letter of 22nd.
That was my case in 22nd November. I am at breach. I know I am at breach. So I am saying that if the contract has stood concluded and you can take your steps under the contract, you will not suffer any loss.
After lunch. After lunch.
Tomorrow, my lord.
Let's finish it.
I'll finish it tomorrow. 12:30 to 1:15 tomorrow. 4 judgments I will cite on this proposition. The damages is to be assessed on the date of breach. You cannot wait and extend the period as per your choice to claim a profit. These are the 2 principles, my lord, I will cite. And finally, my lord, once, my lord, the Sang-Yong judgment. Just the basic principles for
not today.
I'll have some matter. 37. Difficulties with the monthly list coming out. More than me, my juniors are both. My junior friend on the other side, he was also requested.
You'll take.
Lord, I will have to go through the additional documents. So
additional document is key ache. I am not relying on any additional document.
Lord, I'll have a copy, see it through, and Lord, then I'll come back.
We'll try to finish it then tomorrow.
Tomorrow I'll finish it out tomorrow. I'll finish it tomorrow. If 12:30 it can be kept, subject to your lordship's convenience.
I'm not recording it, but yes, 12:30.
Yes.
Heard learned senior counsel, Mr. Shako Sen, listed for further hearing tomorrow. So then let's try to wind it up. You do it after lunch tomorrow. We'll finish it off. All right?
Yes.
We'll try to wind it up. Stretch too much.
Yes.
Your Lordship, leave be given mention to matters which is appear in the today's list. There has been settlement, Your Lordship, item number 689. in commercial division.
After lunch.
As your wish, your lordship. And 689 and one more matter. Item number 702.
Keep it
There has been settlement.
tomorrow.
Okay.
Give the numbers.
Okay.
We'll keep it.
As your wish, your lordship.
may I seek leave for order drawn up of order dated 3rd November 2000. Seek for leave for order drawn up and complete the order dated.
Order, sorry, I didn't.
Order draw up for the complete the order dated of passed by your lordship 3rd November 2000.
There is a process of drawing up and completing any order passed by your lordship. So that is the request.
Much obliged, your lordship.
But
No,
may I
no.
have-
Normal. Commercial division. Acti.
But may I have your lordship's leave?
Much obliged.
To mention a matter, this has meant I mentioned today morning. That my clients are here, the judgment debtors. They have surrendered before the sheriff. They are the sheriff is also here. May
You're taking the matters.
Right.
3 p.m. No?
I am seeking your lordship's leave to mention a similar matter, your lordship. Should your lordship be minded to take up these matters at your...
They're here?
He's here.
We'll take it.
Grateful to it.
Lord, I appear for the award debtor, my lord. He's been arrested and brought, my lord. Lord, I seek 4 weeks time for filing the affidavit of assets and my lord.
Why? You don't know your assets?
My lord, for affidavit of assets, my
Huh?
lord.
You don't know your assets?
Sometime may be granted, my lord, to me. Because I'm appearing on instructions, my lord. I have not received any brief. So the man has been brought, my lord, and I'm appearing.
বাংলায় বলতে পারো
নাম
শারাফত আলী
শরাফত আলী বাবার নাম
আশরাফ আলী
বেঁচে আছে
না মারা গেছে
লেট আশরাফ আলী তোর বয়স
বয়স আমার 48
48 ইয়ার্স বাড়ির ঠিকানা
সেলাডার হাউস রোড মেডিয়াপুরুজ সেলাডার হাউস রোড সেলাডার হাউস রোড
ये
63 বাইয়ে 63 বাইয়ে 7,18,000
7,80,000 ক্যালকাটা 7,80,000 কি করেন আপনি
আমি দর্জির কাজ করি
টেইলার তাকে যেদিকে দরকার বলবে সেই শার্ট পরুন ঠিক আছে
जल्दी
আপনি উকিল বলবে একটা ফর্ম আছে ওটাতে আপনার কি সম্পত্তি আছে তাও এগুলো যদি না করেন তাহলে দর্শক আপনার স্টেপ
Mistake now. The judgment debtor is
My lord,
present
in the
the court.
meantime, my lord, I'll also approach the
Ethical.
execution applicant for settlement.
Formatted, warrant of arrest was issued on 23rd September 2025. 20. Wide order dated 23rd September 2025, this court had issued the warrant of arrest. The judgment by wide order dated 23rd of September 2025, this court had issued the warrant against the award debtor, Mr. Sarafat Ali. Sarafat Ali is present in the court. Oath has been administered. He undertakes to file his affidavit of asset within a period of 2 weeks. He further undertakes to abide by all the directions passed by this court and shall remain present for examination as and when required. Warrant of arrest is discharged. Let this matter appear in the monthly list of 15 January. All right. वो अपना आप एफिडेविट ऑफ एसेट फाइल करिए 2 हफ्ते के अंदर
जो फॉर्म है ना उसमें बढ़िएगा कि आपका क्या संपत्ति है वो गुरु जीत जाएगा
और पेमेंट करिए
तो कारवार उठ गया है सर
पेमेंट करिए यहाँ कोई वो नहीं है पेमेंट करना पड़ेगा आपको
थोड़ा तो समय दीजिए
बस समय लीजिए और पेमेंट करिए
ठीक है सर
नेक्स्ट
Great.
My lord, I appear on behalf of the award debtor.
My lord, I appear for the judgment letter. My lord, I am filing my wakalatnama.
EC 30, please.
Bhadoria, Prashant Singh Bhadoria.
हिंदी में
हाँ
और से कहता हूँ जो भी बोलूंगा सच बोलूंगा सच बोलूंगा
जो कुछ बोलूंगा सच के सिवा कुछ नहीं बोलूंगा।
आपका नाम क्या है?
प्रशांत सिंह भदौरिया।
प्रशांत सिंह भदौरिया। आपका पिता का नाम?
श्री उदय कुमार सिंह भदौरिया। लेट
लेट?
लेट उदय कुमार सिंह भदौरिया।
लेट उदय कुमार सिंह भदौरिया। आपका उम्र?
56।
56। आपका घर का पता?
A15 बालाजी एवेन्यू।
A15
बालाजी एवेन्यू, राजीव नगर, विदिशा, डिस्ट्रिक्ट विदिशा।
राजीव नगर
डिस्ट्रिक्ट विदिशा, मध्य प्रदेश।
मध्य प्रदेश। विदिशा
VIDISHA।
विदिशा मध्य प्रदेश।
जी।
क्या काम का क्या करते हैं?
रोड का काम है, सड़क बनाने।
कॉन्ट्रैक्टर?
जी।
कॉन्ट्रैक्टर बिजनेस। आपको जिस दिन सर बोलेंगे उस दिन आपको आना है, ठीक है
जी।
और आपका वकील फॉर्म मिलेगा, उसमें आपका जो संपत्ति है
जी
उसमें भरना पड़ेगा,
जी
जमा करना पड़ेगा।
जी।
Order date
आप ये नहीं
19
करते हैं
September
तो
22।
आपके खिलाफ सख्त चेक लगेगा।
नहीं करते हैं।
ठीक।
भदौरिया साहब पैसा कब तक देंगे?
सर जल्दी करते हैं।
जल्दी करिए
जी।
और 2 हफ्ते के अंदर आप अपना एफिडेविट ऑफ एसेट फाइल करिए।
My lord, in this matter, the judgment letter number 2 is the wife of judgment letter number 1. Let there be a direction to file affidavit of assets on behalf of both the parties.
Learned counsel for the respondent
आपको वाइफ की तरफ
undertakes
से
to
भी
file the affidavit of asset on behalf of the judgment debtor number 1 as well as 2.
वाइफ शांत हो गई। डेथ हुई वाइफ की।
Next, wife is no more. His wife has passed away. Judgment debtor number 1 only.
Wife has passed.
You have to change the learned counsel for the
change. I'll
learned counsel for the award debtor number 1 states that the award debtor number 2 has passed away. Learned counsel for the petitioner shall take steps to do the needful. Change the memo of title and all.
My lord.
Next.
For the judgment data number 1, my lord. My lord, we undertake to file the affidavit of asset, my lord.
क्या बोलो सबको बोलो की नाम?
My lord, one intelligence, my lord, the cause paper may be supplied because we don't have any paper that may be supplied.
Sir, boys 41.
Who's appearing? You're appearing?
We are not instructed on this matter.
श्यामा
Who's that?
प्रसाद कोहली, रायगढ़, ES जेठिया, ES जेठिया,
इसी नंबर पे
ES जेठिया, जेठिया, डिस्ट्रिक्ट
My lord, I
JETHIA. Is not not 24 paragraph. আপনি কি করেন? এই বালি পাথরের ব্যবসা। বিজনেস। আপনি কি যেদিকে ব্যবসা করবেন সেই দিকে আপনি আসবেন, ঠিক আছে? আপনার আর আপনি আপনার উকিলবাবুর কাছে একটা ফর্ম আছে,
19
ফর্মে আপনার সম্পত্তি আছে, কাগজ আছে, সেটা ভর্তি করে জমা দেবেন। এগুলো যদি না করেন জজ সাহেব আপনাদের কাছে আসবে, ঠিক আছে? ওটা ভরে দেবেন।
पैसे दीजिए जल्दी।
করে দেবো স্যার।
Next.
My lord, kindly direct them to supply the copy of the cause paper. I don't have any
copy of it.
just
kindly
I'll serve them a copy of the application. Just give me the copy.
So, Lordship, I appear on behalf of the judgment debtor.
I appear for the award debtor. Award holder, my lord.
Lordships, I'll just be candid, Your Lordship. There was an affidavit of service which was filed, Your Lordship. However, upon instructions, I'm submitting that I have not received the copy of the affidavit in support of the tabular statement. Be that as it may, Your Lordship, today I'm in quicksand. Your Lordship, I'm only praying for Your Lordship's charity to allow me a further 2 weeks to file my affidavit of assets.
That
I am the erring party here. There's no quandary with that. Lordship will just kindly grant
We'll serve another cause paper, my lord. Today I seek, my lord, that there is the asset, my lord, movable asset that can be attached, my lord, and he needs to say the whereabouts of the asset, my lord. The asset is a truck, my lord. It's
File the affidavit of asset.
no, my lord. But
Lordship,
today,
then
where he can say the whereabouts of the asset, and it's 11 lakh, my lord. They can produce the truck, my lord, and we can sell that and take about the amount, my lord.
Your Lordship, perhaps subject to
Yes.
correction by my learned senior, Your Lordship, for that he will need to be examined orally. That is only pursuant to me filing my affidavit of assets. As I understand, Your Lordship, this is a collateral that is there. Your Lordship,
No, my
I'll
lord.
file my affidavit of assets within 2 weeks. Your Lordship will just give me
Well,
that liberty.
That,
Then, Your Lordship,
that question can be put right now, my lord. Where is the whereabout of the asset, my
the
lord?
question of attachment, Your Lordship, perhaps at this stage.
It can be brought, my lord, and we have seeking. There is a prayer for injunction also, my lord. That was not granted at the first occasion, my lord, because they were not appearing, my lord.
It will be served upon me, Your Lordship.
Today, I just seek, my lord, that injunction be there, or question be put to the person that whereabout of the asset, my lord.
Lordship,
Or that asset can be produced to the before the award holder, my lord.
सर थर्ड पार्टी को सर दिया हुआ
ट्रक बेचिएगा मत
नहीं सर
पेमेंट कब तक करेंगे
कर देंगे सर सर जो लोन लिया हुआ था सर उससे ज्यादा ही अमाउंट मैंने पे कर चुका है
इसमें एक लाइन डालो इट इज पुट टू द award debtor. The award debtor undertakes not to sell, alienate, or incur any encumbrance on the vehicle bearing registration number WB29A3612. Full stop. He further undertakes to file his affidavit of asset within a period of 2 weeks. He further undertakes that he shall remain present for examination as and when required.
Your Lordship, subject to correction, perhaps one line.
19 September.
Your Lordship, subject to correction, perhaps one line to the effect that the warrant of arrest stands discharged
So that
as
is,
of now.
That is
As of well, respondent number 2 also they undertake.
Judgment letter number 2.
Are they representing respondent number 2, judgment number 2 also, my lord? If they are
both of them,
then
number 2 has
yes, and one
was taken into custody and 2 has surrendered before the office of the learned sheriff.
both of them are directed
both
to file.
all both of them. उसमें रिया जजमेंट पेपर नंबर 2 में डाल देना he has surrendered before the court. The warrant is हाँ जो नहीं your number 1
number 2
is number 2 number 1 जो है number 1 का डालो he has surrendered before the court. Before the court. Arrested.
1 was arrested, 2 has surrendered before the office of the learned
So
sheriff.
1 was arrested and produced before the court, discharged. Number 2 has surrendered before the court, warrant of arrest discharged. Take. Discharged.
मैं हमसे कहता हूँ जो कुछ बोलूँ सच बोलूँगा सच के सिवा कुछ नहीं बोलूँगा ठीक है क्या नाम है आपका
विकलेश कुमार पाठक विकलेश कुमार पाठक
विकलेश
KALESH
विकलेश कुमार पाठक पिता का नाम
राजदेव पाठक RAJDEO
जिंदा है वो राजदेव पाठक DO राजदेव पाठक आपका घर आपका उम्र 36 घर का पता
हावड़ा हांसकालीपुर
पूरा
हांसकालीपुर
हावड़ा इस पता पे आपका छुट्टी चला जाएगा
नहीं 52 रविंद्र नगर
तो पूरा बताइए 52 रविंद्र नगर
चांदमाई रोड
4 माइल रोड
हांसकालीपुर
रविंद्र नगर 4 माइल रोड
हांसकालीपुर
हावड़ा कितना
71109
और आप क्या काम करते हैं
प्राइवेट फर्म में काम करते हैं
प्राइवेट सर्विस आपको
नॉट सर्विस टेम्पोररी
सर्विस ही तो करते हैं आपको जिस चीज बोलेंगे उस दिन आइएगा ठीक है और आपका वकील का फॉर्म होगा उसमें आपका जो संपत्ति है उसका पूरा हिसाब डाल के जमा कीजिएगा समझ गए अगर आप नहीं करते तो जज साहब आपके खिलाफ एक्शन लेंगे ठीक
Grateful to you.
Grateful.
24 और 2025 চোলামণ্ডলম ফিনান্স ইনভেস্টমেন্ট আচ্ছা জ্যোতি এটা ইন্টারনেটটা হবে
Lord, I beg to
You are for the
my lord.
awarded.
Lord, I am seeking for my lord 4 weeks time, my lord, to file my lord my affidavit.
2 weeks.
As your lordship.
क्या नाम आपका
Abhishek Singh.
अभिषेक सिंह
And my lord, in the meantime, my lord, direction be given to submit the copy of
Give a copy of
so that I can make up.
अखिलेश सिंह उम्र 37 ईयर घर का पता
152/7
152/7
हरिदत्त राय चमरिया रोड
अली दत्त राय
हरि
हरि दत्त राय चमरिया रोड
हावड़ा
हरि दत्त राय रोड चमरिया राय
चमरिया रोड
चमरिया रोड
हावड़ा
हावड़ा 1 क्या काम करते हैं
कंप्यूटर सेल्स एंड सर्विस
कंप्यूटर सेल्स सर्विस बिजनेस ही करो
हाँ बिजनेस
हाँ, आपको जिस दिन अच्छा बोलेंगे उस दिन आपको आना है ठीक है और आपका वकील का फॉर्म है उसमें आपका
order
जो
dated
property है,
17
property
September
है,
2020.
डालना है, जमा देना है ठीक है
Award dated
आप
number 3
नहीं
Abhishek.
करते हैं तो अच्छा वकील फिर टेस्ट से
पेमेंट करिए.
चलो विद लिमिट
Next.
My lord, I appear on behalf of the award holder.
My lord, I am appearing on behalf of the judgment dated number 2.
ধর্মকে বলতে যা বলবো সত্য বলবো হ্যাঁ যা বলবো সত্য বলবো রামায়ণ মহাভারত বলতে পারি নাম আপনার নাম কালীপদ ভট্টাচার্য কালীপদ ভট্টাচার্য বাবার নাম অধীর কুমার ভট্টাচার্য লেট অধীর কুমার ভট্টাচার্য হ্যাঁ আপনার বয়স 69 হলো আধার কার্ডে একটু কম হয় 69 ইয়ার আপনার বাড়ির ঠিকানা কিশোরপুর পুরোটা বলুন পুরো ঠিকানা করিমপুর থানা আর নদিয়া জেলা নদিয়া কিশোরপুর গ্রাম পোস্ট অফিস ভিলেজ কিশোরপুর পোস্ট অফিস ও কিশোরপুর ভিলেজ আর পোস্ট অফিস কি করেন আপনি আমি দুটো চপ আর মুড়ি ভাজি বাবা
অ্যালাউ করবে না আপনি বলে দিন আর কি
আপনাকে যেদিনকে দরকার বলবেন সেদিনে আপনি আসবেন ঠিক আছে আর আপনার
By order dated
ঠিক আছে
25th September.
ফর্ম করে আপনি জমা করবেন
Award dated number 2.
যা আছে নেই তাহলে নেই লিখবেন কিছু নেই নেই লিখবেন যে কখন জমা দেবেন আপনি যদি না করেন লিখবেন তাহলে আপনার কাছে স্টেপ নেবেন আপনি কিছু না থাকে তাহলে লিখবেন না
Tell him to make the payment.
আপনাকে জজ সাহেব বলছে যে টাকাটা বাকি আছে সেটা দিতে ওই গাড়িটা একজনকে দিয়ে দিয়েছে কিস্তি চালাইতে পারেনি বলে সে দেয়নি
My lord,
কিন্তু লোনটা তো আপনার নামে না আমাদের
if I may, the judgment data number 1 is the son of judgment data number 2 here.
দিয়েছেন সেটা তো
Today he unable to
যেহেতু
come to
লোনটা আপনার
before
নামে
my lord. Tomorrow he shall surrender. He is out station.
Let him surrender.
কাউকে ধরবে না
My lord, in the meantime, a copy may be
Next.
My lord, I'm for the judgment data number 1.
My lord, I'm
धर्म से कहता हूँ बोलूंगा सच बोलूंगा कुछ नहीं बोलूंगा
सच बोलो सच कुछ नहीं
क्या नाम है आपका
नरेंद्र बहादुर सिंह
नरेंद्र बहादुर सिंह आपका पिता का नाम
लेट राज बहादुर सिंह
लेट राज बहादुर सिंह आपका उम्र
68
68 ईयर घर का पता फुल एड्रेस बताइए
5 रखी
5
विलेज 5 रखी
विलेज 5 लक्की
पोस्ट सुगंधा
पोस्ट पीओ सुगंधा
डिस्ट्रिक्ट हुगली
डिस्ट्रिक्ट हुगली
712123 पिन
712123 और आप क्या करते हैं
मैं बिजनेस ही करता हूँ
बिजनेस आपको जब जिस डेट से आने बोलेंगे आपको आना है ठीक है
20 by order dated 25th
आपका
September.
फॉर्म मिलेगा उसमें आपका जो संपत्ति है प्रॉपर्टीज है उसको भर के जमा देना है। अगर आप नहीं करते तो
पेमेंट करिए सिंह साहब।
ठीक है सर।
कितना जल्दी हो
My lord, there is a 1.5 lakhs each month for 64 months already paid. Down payment 62. Now, as my calculation, it is 96 already paid. So principal, okay. Interest is 30 lakhs already paid. I really don't know how much I have to pay. Asset already taken by them, sold and the settled. Even the account saying,
Approach them, get a settlement done.
my lord.
My lord,
My lord,
may there be a direction
My
to
lord.
file affidavit of assets on both the judgments?
My lord, I require 3 weeks because his wife is in medical urgency and she is in Delhi. So from Delhi to Calcutta is a little bit troublesome. So I require 3 weeks time.
3
my
weeks.
lord. Grateful.
Grateful.
Next.
Ici comme 97 of 2025 and it versus
Jhalkani. 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 Yes.
Both admit. Make the payment, Mr. Call.
follow me affirm in whatever I shall depose, I shall speak the truth, nothing
Only
but
I am for
You become a such
आपका नाम
Mohit Call.
filing the affidavit.
कॉल KUL
KAUL.
ये बोलिए आप बोलिए।
आपका पिता का नाम
Late Samir Call. SAM
SAM
double ER.
समीर कॉल। आपका उम्र
33 years.
33 years. Full address
266
266
P/B
P/B
Ward 2
Ward
Mehrauli
Mehrauli
New Delhi
New Delhi
110030.
110030। और क्या what do you do? क्या
I'm a sportswear manufacturer. Sportswear manufacturer.
business. Come on the day when my lord, you have to come in
25th September 2025. Board
file
data
your
number 2.
affidavit of assets in a specific form. You will get from your
हो गया?
lawyer
खत्म?
and
Last?
submit it.
सर आप
So,
ये बोलिएगा उसको सबमिशन के बाद आप बोलिएगा।
my lord will take action against you. Right?
Make the payment, declare an asset.
My lord gives a liberty to file a bakasa, my lord.
File it in the department.
Your Lordship, I am for the award holder and direct him filing the affidavit assets.
Also, sir, also give a direction to give a copy of
Give a
your
copy of that.
Yes, I will give it to him, but give them.
Next.
My lord, I appear on behalf of the award holder.
The award data number 3 is the award data number 2's wife. She is also present in court.
Probit Pal.
Filer
affidavit
of assets.
বয়স কত আপনার
44
44 আপনার বাড়ির ঠিকানা পুরো ঠিকানা
সরকারপাড়া
সরকারপাড়া
বোসপুকুর
বোসপুকুর
রাজপুর
রাজপুর
বোস
বোস BOSC বোসপুকুর
রাজপুর
রাজপুর
কলকাতা
কলকাতা
700149
700149 আর আপনি কি করেন
ম্যাচ বক্সের বিজনেস ছিল
বিজনেস এখন কি করেন ছিল না এখন কি করেন
এখন তো ওই বিজনেসটাই বন্ধ
আনএমপ্লয়েড কোনো বিজনেস ক্লোজ আপনাকে জজ সাহেব যেদিনকে বলবেন সেদিকে আপনি আসবেন ঠিক আছে
Award dated
আর আপনার
audited 25th September 2025.
ফর্ম
Affidavit of asset within 2 weeks.
আপনার স্থাবর অস্তবিদ্য সম্পত্তি
Award
যেটা
data number 2.
ওই ফর্মটা
Even
করে
award
দিতে
dated
হবে।
number 1 is present in the court and
আপনি
undertakes
এগুলো
to
না
file the
করেন তাহলে
affidavit
জজ
of
সাহেব
asset.
আপনার কাছে আসবে না
2 is Prashanto Paul. Wife. That wife is number 1.
Wife is number 2. No, I'm sorry, number 3. Number 2 is him.
Number 3. Award dated number 3 is also present and undertakes to file the affidavit of asset within 2 weeks. Number 2, number 3. Within 2 weeks. File your affidavit of asset and give the payment.
পেমেন্ট করুন আর ওই যেটা বললাম যে সম্পত্তি যেটা
Discharge.
ওটা অ্যাফিডেভিট ফর্মে করতে হয় ফর্মটা পাবেন পেমেন্ট করুন আপনারা গেছে
Nah.
Call the appellate side matter.
Grateful.
Grateful, Lodge.
Appellate side. अच्छा ओरिजिनल साइड मैटर नॉन कंपेरेटिव इनका जो है एनसी केएमसी ये वाला है अच्छा
Commercial matter.
Non-commercial.
Commercial matter. Partner matters. Item number 1. 1 and 2. Sorry.
These are unanticipated yes tasks which we are given.
Well, on the last occasion, Milord, I was placing the sections of the Act to demonstrate before your Lordship, Milord, what is the intention of the legislature. Milord, I have completed Part 9A of the Constitution, the lawmaking power which emanates or flows from Part 9A. Then, Milord, I have come to, Milord, the Act.
Right.
Now, Milord, I had placed, Milord, up to 179 2D.
Yes.
Milord, in 179 2D, Milord, I had requested your Lordship, Milord, to
Mark the word outstanding.
outstanding. Milord, there is another word before that, any outstanding. Deemed to be valid and any outstanding property tax, so and so. Then, Milord, your Lordship may kindly take, Milord, section 180.
100?
180. Notwithstanding anything contained in section 179, the corporation, subject to the prior approval of the state government, may by resolution direct a general revaluation of lands and buildings in any ward of the corporation or part thereof during the currency of any period specified under this chapter. Such general revaluation shall have effect from the beginning of the quarter following, in which a notice, I think should be under section 184 is issued and shall remain in force in respect of each ward or portion thereof, as the case may be, for the unexpired portion of the period during which, but for such revaluation, the annual valuation would have remained in force. The municipal commissioner may cause any revision to be made in the annual valuation of the land or building in the following cases. Milord, we have the cases over there. Now, after Milord, clauses 1 to Roman 9, please take the proviso under subsection 2. Provided that such revision of annual valuation of any land or building shall ordinarily be made within 6 years from the date of occurrence of any of the above circumstances, but such period shall not apply where the owner or the person liable to pay property tax fails to submit return under section 182 or suppresses the occurrence of such circumstances. Please also, Milord, note the expression ordinarily. And Milord, I'll sum up all these provisions, Milord, at the end. So this revision would take, Milord, ordinarily within 6 years, which may be expanded also. That is why, Milord, the word is ordinarily. Now that your Lordship takes up, Milord, arbitration matters in section 34, so far as the period of limitation is concerned, there is a phrase, yes, and no further.
And no further. Yes.
Which means that,
that is
90, 30,
30, that's it.
That's all.
120, not beyond.
Nothing more than that.
Nothing more.
But here, Milord, the statute uses the expression ordinarily, which means that it is expandable. But I skip over, Milord, subsections 3 and 4, Milord, may not be relevant for my purpose over here. Then comes, Milord, section 182. Where this speaks of, Milord, obligation to file a return. to enable the commissioner to revise the annual valuation of so-and-so under subsection 2 of section 180, except in cases under clause 5, the owner or person liable to pay property tax for such land and building shall furnish to the municipal commissioner not later than 31st day of March of the year immediately following a return in such form as may be prescribed, provided that where the owner and or the person liable, primarily liable, or the person liable to pay the property tax fails to submit the return in the prescribed form, then, notwithstanding anything contained in this chapter, the municipal commissioner may revise the annual value upon service of notice under section 184, and such revision shall take effect in accordance with 183. Then, my lord, 182A again is, my lord, self-assessment and submission of return, my lord, under the new system, unit area assessment. But please take the proviso after, my lord, 182A1A. Kindly turn the page at page 88 top. Provided that in case of non-filing of return of self-assessment, notwithstanding anything contained in sections 171, 179, 180, 232A and 232B, till fresh valuation is made after publication of the scheme, existing tax as mentioned in this subsection may be increased every year on and from the date of final publication of the scheme, and such percentage not exceeding 5% as may be decided by the corporation, and such owner or occupier or person liable to pay the property tax as the case may be shall continue to pay, which shall be subject to adjustment after fresh valuation of the scheme. There are two important aspects over here. Number one is, this is a recurring liability. You need to go on paying. And number two is that after revaluation, if some adjustments here and there is required, that can be done. My objective is to demonstrate before this court two things. Number one, this is a recurring liability. And number two is, the statute does not take a retrospective effect as has been argued on behalf of the petitioner. What happens is, after revaluation, the outstanding adjustments remaining, whatever various terms have been used in various portions of this chapter, I'll highlight all of those. It is not a new assessment, number one. And number two, it does not take a retrospective effect. You only pay the balance. This appears to be the scheme according to my understanding of the subject. Then kindly take the next proviso. Provided further that if any change in the nature of occupancy or in the nature of or any addition, alteration, such and such occurs prior to the final publication of the scheme, then the corporation may amend the assessment and consequential tax mentioned in the foregoing proviso. Here we get the expression consequential. গরম লাগছে একটা পাখা একটু চালাবেন Then may I skip over B may not be relevant, my lord. Please take, my lord, subsection 3. Yes. The payment of such property tax and interest up to the current quarter, if any, shall be made, and such return shall be furnished within such period as the corporation may by order determine of the date of final publication of the scheme under section 174. Then I skip over 4. I skip over 5 also. Please take subsection 6 of 182A. After the assessment under 179 or revision of assessment under 180 has been made, any amount paid on self-assessment under this section shall be deemed to be paid on account of assessment under 179 or 180 as the case may be. If the owner or other person liable to pay property tax under this act fails to pay the same together with interest, if any, in accordance with the provisions of this section, he shall without prejudice to any other consequences to which he may be subject be deemed to be a defaulter, etc. Then 8. After the assessment is finally made under this act, if the payment of self-assessment is found to be less than that the amount payable by the assessee, in such case the assessee shall pay up the difference within 2 months from the date of assessment, failing which recovery shall be made such and such. So you go on paying under 182A 5%. Then upon final assessment, pay the difference. Then, my lord, the other mechanism of natural justice notice, hearing, etc. I don't trouble your lordship, my lord, for the time being. Now, please take, my lord, two other sections. One is section 217, 217.
Notice of demand, notice.
Please take now 217.
Interest and penalty.
Oh, I can skip over 217. But I can skip over 217. Now, please take, my lord, 232A and 232B. Two 232A says certain provisions applicable prior to enactment of the 2006 amendment shall continue to be in force, notwithstanding any contained in this act. The provisions of section so and so, which were in force immediately prior to the commencement of the Amendment Act of 2006, shall continue to be in force until final publication of the scheme under subsection 1 of section 174 of the Act as amended by the Kolkata Municipal Corporation Amendment Act 2006, provided that the preparatory works under so and so shall be amended under such and such. Then 232B. Notwithstanding anything contained in this Act, the provisions of subsections so and so of 171, 174, 175, 179, 180, 182A and 185, which were in force immediately prior to the commencement of the 2006 amendment, and subsection 3 of section 174 shall continue to be enforceable in respect of any action as to be taken for the purpose of assessment of annual valuation and levying of property tax or any step relating thereto for any period prior to publication of the enforcement of the scheme under subsection 1 of section 174, read with clause A of subsection 2 of 179 as amended by the KMC amendment. Therefore, my lord, the gist is 179 2DII speaks of paying the outstanding. 182A1 proviso speaks of adjustment after final valuation. 182A3 speaks of recurring obligation to pay during, during the interregnum, switching over from the previous one to the assessment made under the new system. Then we have 182A6, which speaks of deemed payment under 179 and 180. Then 182A7 speaks of defaulter if not paid, and 182A3, no, 182A8 speaks of difference to be paid. And Miller, one section where I'm so sorry, Miller, I have forgotten to place. Very well, I can skip over that. Now, Miller, in summation of Miller these provisions, My respectful submission is that, Miller, there is no new liability that is being put to the assessees. It is only, Miller, for a switchover or for a fresh annual valuation. Miller, the difference has to be paid with your recurring obligation to pay continuing. Miller, this is, Miller, my first limb of submission. But my next limb of submission is, as in the beginning I have said, that what is this property tax? A property tax is not a tax, Millard, on an individual. It is a tax on the property itself. And in a case of default, it is recovered from the property itself.
Yes. Yes.
Another 40-45 minutes.
Sorry. I think it's good for the day.
But 170 clause A and 171 subsection 1 word I placed on the last location to demonstrate that a property tax is a tax on the property itself. Today, Millard, I'll place sections 195, 170, 97, 214 and 219 onwards, which prescribes the procedure for recovery of the tax in a case of default. You have to recover it from the property itself. For example, kindly have a look at 195 once. First is, Millard, in 195 speaks of recovery from the rent earned from the property. On the failure to recover any sum due on account of property tax on any land or building from a person liable, therefore, under section so and so, the Municipal Commission shall, notwithstanding any contained in the Premises Tenancy Act or in any other law for the timing in force, recover from every occupier of such land or building by attachment of rent payable by such occupier a portion of the total sum due, which bears as nearly as may be the same proportion of to that sum as the rent annually payable by such occupier bears to the total amount of rent annually payable in respect of the whole of such land or building. An occupier, then we have the remedy of the occupier. Then please take, Millard, 197. This, of course, Millard, is upon appeal. Millard, we can skip over this. Please come to, Millard, section 214 then. In fact, this chapter, that is 16, under which, Millard, 214 onwards is there. The heading of the chapter itself is payment and recovery of taxes by the corporation. 214 says the manner of recovery of taxes under this act. Save as otherwise provided in this act, any tax levied under this act may be recovered in accordance with the following procedure in such manner as may be prescribed. Please take D and E. D says by attachment and sale of the defaulter's immovable property, and E says in the case of property tax on land and building by attachment of rent due in respect of the land or building. So it is recovered from the property itself. Now skipping over a few sections, please take 219. But these are all mechanisms. Just note down the sections. I need not waste your lordship's time. 219 is, Millard, one of the mode by issuance of warrant. Then 220 is, Millard, distress sale. 221 is also the same. 221A, attachment of the immovable property. 221B, sale of the property. 222 is if a person is about to leave Kolkata, what is to be done. Then we have the Public Demands Recovery Act, which is 223, 224, 225, payment of rent, 226. This goes on till 232. But this is the detailed procedure, but I just really highlight these sections, Millard. This is how, Millard,
recovery can
tax is recovered in a case of default. Now, Millard, the next point is, Millard, on the point of limitation that my learned friends have argued before your lordship. Millard, to argue, Millard, the point of limitation, Millard, they refer to, Millard, section 573 of the Act, read with, Millard, a previous judgment of our court, division bench of our court, which does not notice previous judgments of this court itself. Now, why these sections are important? I mean, the process of recovery, because Millard, our High Court has said that 573 would not apply where the process of recovery is mentioned in the statute itself. This 214 onwards till 232 are, Millard, the provisions which takes care of how recovery is to be made. So the question arose whether 573 would apply even in a case of property tax or not. But our division bench as well as single benches may have held that no, 573 would not apply because the procedure is mentioned elsewhere in the Act. Kindly have a look to me at 573. Save as otherwise provided in this Act. And there is a proviso which creates a sort of a limitation to recover.
3 years. 3 years is it?
3 years. First is, Millard, 573 would not apply if otherwise provided in the Act. Otherwise provided, Millard, I have demonstrated from section 214 to 232.
Yes.
The proviso again is confined to the 473 itself because it says any sum under this section. 3 years is the limitation for recovery of any sum under 573.
Yes.
Now, I need to, Millard, place 2 or 3 judgments on 573 before I come to the previous Sahu Jain judgment of 2018, which has been relied. But please take note the division bench judgment of our court reported in AIR 1998 Calcutta 304. I have not handed up any bunch mirror. No, it আমরা দিইনি, আমরা এখনো দিইনি। This is AIR 1998 Calcutta 345. Dear Lordship, may kindly take me, since there is no paragraph number, please take me printed page 8.
Yes,
But I'm reading from the top.
that's the section.
There is no doubt. It starts like this. There's no doubt that there exists no provision for limitation so far as recovery proceedings are concerned. Mr. Banerjee, however, has relied upon section 573 of the Act, which provides for recovery of certain dues and reads as so and so. But after quoting the section, section 573 occurs in part 3 of chapter 16, which deals with power procedure offences and penalties. Section 573 on a plain reading cannot have any application with regard to recovery of tax, interest or penalty provided under chapter 16 of the Act. It is now well settled principles of law that a due of a person, it should be realizable from another, does not efface nor the claim of such person stands extinguished even in a case where Limitation Act applies. In terms of the provisions of the Limitation Act, recovery of a sum by taking recourse to filing a suit becomes barred. Limitation Act 1963 cannot have any application in regard to recovery of public dues unless a statutory provisions exist therefore. Section 29 of the Limitation Act is quoted, Millard. Then thereafter, after quoting Limitation Act, next page, a special statute may provide for limitation or may not. In the instant case, the proviso appended to section 537 of the Act only provides for limitation. 537 cannot have any application in realizable to tax in relation to taxes, inasmuch as by reason thereof a legal fiction has been created. By creating a legal fiction, a putative or imaginary state of affairs is treated to be a real state of affairs, though it is not. The wordings of the provision, particularly the words employed in a provision of restrictive statute, should be construed in such a manner so as to enable the court to give full effect thereto. The proviso appended to section 573, which makes out an exception, provides for a limitation as regards recovery of imposts stated therein, which was to be recovered as a consolidated trade, meaning thereby such recoveries inter alia would be made in terms of provisions of section 220. But if any limitation for recovery of taxes was to be provided, the same should have been done by using clear and unequivocal language by the legislature in chapter 16 itself. Recovery of tax is also an incidence of taxation. It is well said known that there cannot be any intendment so far as imposition of tax is concerned, and in that view of the matter, there cannot be any intendment so far as the recovery of tax is concerned, nor any presumption can be raised that upon expiry of certain period, such taxes cannot be recovered. A provision for limitation can only be brought about by a statute. Such a statute in certain cases may be statute of repose, but the legislature in its wisdom may not make any provision there. Therefore, if any limitation was required,
yes,
as per Millard, the division bench of our court, Millard, it ought to have been provided in chapter 16 itself. That is section 214 onwards. But there are two single benches also, just as a follow-up I am showing. One is Miller 2003, 1 CHN page 318. 380. I'm sorry. 380. Zero square. Well, I'm sorry, Miller. Some mishandling with the page because the SCC. I do not know why the SCC does not have the full print of this judgment. Please take paragraph 7 only. This is a single bench judgment. After hearing the learned counsel for the parties and after going through the provisions contained in section 573 of the Act, I am of the view that the aforesaid sections apply only to cases of recovery of amount of any charge, cost, fees, expense, rate, rent, or any other, or on any other account for which no mode of recovery is provided for in the Act, and in such cases, such amount should be recoverable as if it were a consolidated rate, provided, of course, that no proceeding for recovery of any sum by taking aid of section 573 should be commenced after lapse of 3 years from the date on which the sum became due. Yes. But there is another single bench which is after the previous Sahujan, where this is 2023 SCC Online Calcutta 5723. Please take only one paragraph, para 31. It's the longest judgment. But this is in respect of recovery of Millard's stall charges. In so and so, though the coordinate bench video order dated 13th May refused to interfere with the demand made by the KMC, but it has specifically been recorded in the said order that the decision was taken since the authority of KMC under section 430 to levy demand was not questioned, but in Nepal Chandra Court, where that is the single bench which I have placed, in the context of applicability to proviso to section 573 relating to limitation of 3 years provided therein for initiation of proceedings for recovery of any sum, it has been decided in paragraph 7.8 that section 573 applies only to the cases of recovery of amount of any charge, cost, expense, fee, rate, rent, or any other account for which no mode of recovery is provided in the Act of 1980. But in connection with demand for area stallage, section 573 is not applicable in view of the authority provided under 432 1C, since it has been provided therein that the municipal commissioner may close the stall or shop when a person found to be in default of payment of stallage or rents or any other dues to the corporation till payment is made or recovered under the provisions of the Act of 98. Therefore, the contention of the petitioners that the authority of KMC is circumscribed by the proviso to section 573, since it has been provided therein that no proceedings to recover the dues can be initiated beyond the period of 3 years from the date on which the amount becomes due, is inapplicable in the present case, since the demand notice was issued against the petitioner towards area stallage and other fees. On perusal of the decision in Nepal Chandra Court, this court finds that the case of KMC relating to demand notice claiming area stallage and other related dues is fortified. This is another example where in case of stall, what will happen? 432 provides for a separate procedure, therefore 597 will not apply. Now, Millard, I come to the decision on which, Millard, reliance has been placed by the petitioners. Millard, this is 2018 3 CHN 328. But I think page 30 of the compilation which has been handed
which
up.
one? Mr. Datta, which one?
Page 30 of the compilation. But this has been filed by the writ petitioners
Indian city property.
in Indian city properties.
Indian city. Yes.
Now, Reliance is placement on this judgment.
Yes.
Well, I'll
the other two judgments on which you have relied, you said they have not considered this.
Yes. But at least the single bench orders may not be considered by a division bench. But so far as a previous division bench is concerned, that ought to have been considered. This would be my respectful submission. In 2004, the writ petitioners filed a writ petition in this court challenging the virus of the second proviso to section 179 2D of the Act. They also challenged a demand. Learned counsel appearing for the appellant in that writ alleged on a mistaken interpretation of the instruction given to him abandoned the point of virus. On 20th of April 2007, the writ application was disposed of, taking into account the above concession. Then we are skipping over a few paragraphs. Please take note para number 13, where Millard 179 2D with its proviso is quoted. Then Millard in para 17, 573 is quoted.
Yes.
Then Millard in 18 Millard, the Honorable Division Bench Millard was considering the implication of 573. The proviso is very important. It says that no proceeding for recovery of inter alia municipal tax shall be commenced after a lapse of 3 years from the date on which the sum became due. Under the second proviso to subsection 2 of section 179 of the Act, the proviso to section 573 would be rendered ocious by giving the Commissioner the power to collect unlimited tax by unrestricted revision of the annual valuation of the premises for an unlimited period of time. Theoretically, the tax would become due on the date of the revision made by the Commissioner, but the real effect is that the person liable to pay tax for a property could be fastened by the Commission with liability to pay tax otherwise not realizable long after the period of limitation. Then, Millard, the judgments are considered from paragraphs 19, 20, 21, 22, 23, 24. Now, please take 25. The power conferred on the municipal commissioner to revise the annual valuation of the land or building under section 179(2), second proviso, was indeed unlimited in point of time and very wide in its amplitude. Any piece of legislature where unguided or uncanalized power is given to an authority to that extent invalid. Therefore, the power conferred on the commissioner, in my opinion, is indeed so unlimited that it falls foul of Article 14 of the Constitution. Then skipping over Millard one paragraph, please take para 27. We adopt the same procedure. The commissioner can only have the power to revise valuation within a reasonable period of time. In case of so and so, the Supreme Court computed reasonable time in the subject act to be 3 years. In section 573 of the KMC Act, the corporation has the power to recover any sum by initiating a proceeding within 3 years from the date such sum became due and payable. Therefore, on a proper interpretation of the proviso and upon reading it down to save it from unconstitutionality, the period for which valuation of a property can be raised must not be more than 3 years before the date of revising the order. But with respect, Millard, previous judgments not looked into. With respect, Millard, chapter 16 has not been looked into. And Millard, simpliciter looking into section 573, Millard, the division bench proceeds on the basis that it is property tax is included in it and the period of limitation is 3 years. Now, Millard, in this situation, what is to be done? Because before your Lordship, today, Millard, we have two conflicting views of the two division benches. Now, when the Supreme Court recently had the occasion to deal with this kind of a situation.
Not really, Mr. Gupta. These are not two conflicting opinions. There are two different interpretations given to
very well.
section.
Yes.
So I don't see a conflicting.
Very well. Very well. But in that case, Milord, may I make this submission, Milord? Today, Milord, your Lordship, Milord, has to decide on the basis of the arguments which are being made by the parties. I may be right, I may be wrong. According to me, Milord, 573 is not applicable. Why? Because 573 carves an exception to the other provisions of the Act. If the other provisions of the Act did not, or the relevant provisions of the Act for recovery, because when corporation, but maybe I am making some overlapping submissions which may be made by the corporation, because since I am the lawmaker, obviously the intention of the legislature has to be portrayed before the court. Now, when corporation initiates a proceeding of recovery of area property tax, corporation would not take recourse to 573.
Yes.
Corporation would take recourse to the provisions under Chapter 16. But legislature thought it fit that no limitation should be prescribed in respect of recovery of area taxes, property taxes. Please consider whether by way of a judicial fiat, a period of limitation can be introduced in it or not. If so, my respectful submission would be that it would amount to, as your lordships have always said, judicial legislation or rewriting the statute, because we do not require over here to read down any provision. Well, my case is very simple. That legislature thought it fit not to prescribe a period of limitation. Therefore, you cannot trace out some limitation from another part of the statute and apply it over here. If the legislature intended to prescribe a limitation, the matter would have ended over there. They would have prescribed a limitation over there. And as your lordships have always held, that in fiscal statutes there is no scope of any intendment. Well, this is one of the golden principles of Miller fiscal statute.
Absolutely.
No intent.
No intent.
Either it's there or it's not there.
You can't read into it.
Yes. Therefore, either 573 applies or it doesn't apply. My submission is in the garb of chapter 16, 573 has no manner of application. Because 573 is taken recourse to over here in the facts of this case only to ensure that whatever is recoverable does not go back more than 3 years. If at all it is a new realization, which according to me is not, because the other provisions of the Act says that you have a recurring liability to go on paying every quarter. After revaluation, after fresh valuation, whether it is under the UA system or the previous one, the balance, difference, outstanding, this is only to be recovered. The entire tax is not recovered. Huh? আপনি কিছু বললেন না? কি বলা হয়েছে? Well, only one judgment. Please have a look to this judgment. Then I am over. But on a plain reading, let us, Millard, take the case made out by the petitioners that it would amount to recovery of a tax from a back date, from a past date.
Okay.
Is it retrospective or not? Millard, there's a 1980 judgment of the Supreme Court, where the Kerala Building Tax Act was promulgated, and one-time tax. That was not a recurring one. And it was given a retrospective effect. Therefore, the question arose that if you promulgate the statute in, say, 1978, how can you recover tax from 1973? So the retrospectivity issue was taken note of and considered by the Supreme Court. Please have a look to this judgment. This is 1980, Volume 2, Supreme Court cases 410.
Yes.
Well, paragraph number 1, these cases relate to the validity of certain provisions of the Kerala Building Tax Act 1975 and are directed against the judgment of so and so. Please take subsection 3, paragraph 3. The legislature of the Kerala state wanted to impose a tax on building and passed the Kerala Building Tax Act 1961, which came into force in 1961. Its validity was challenged by a judgment. The learned single judge of the High Court held it to be invalid and unconstitutional. Then, it was upheld up to the Supreme Court. Then, comes, the new act. Please take, about 10 lines from the top in para 3 itself. The intention, where there's a sentence starting with the intention to introduce a fresh bill and to levy a non-recurring tax on building was stated in the finance minister's budget speech of 1970-71. A bill was published sometime in June 1970, and it was stated there that the act would be brought into force with effect from 1970. The bill was introduced in the Legislative Assembly on 5th July 1973 and was referred to a select committee. The committee submitted its report on March 28, 1974. It recommended the act may be brought into force from April 1, 1973. As the bill could not be taken up during the budget session, the government of the state promulgated the Building Tax Ordinance 1974 on July 27, 1974 to give effect to the provisions of the bill as reported by the Select Committee. It was followed by another ordinance dated so and so on the lines of the earlier ordinance. The bill was passed soon after the governor gave his assent to it on April 2, 1975. Then para 4. The question which arises for consideration at the threshold is that relating to the competence of the state legislature to enact the law on which considerable stress has been laid by Mr. So-and-so. Kindly take now paragraph 8. Entry 49 of list 2 is quoted. Thereafter, if therefore a tax is directly imposed on buildings, it will bear a direct relation to the building owned by the assessee. It may be that the building owned by an assessee may be a component of his total assets, but a tax under entry 86 will not bear any direct or definable relation to his building. A tax on building is therefore a direct tax on the assessee's building as such and is not a personal tax without reference to the particular property. It has to be appreciated that in almost all cases a tax has two elements, which has been precisely stated by Sirvai in the Constitutional Law of India, 2nd edition, volume so and so. I read the quoted portion. Another principle for reconciling apparently conflicting tax entries follows from the fact that a tax has two elements: the person, thing or activity on which tax is imposed, and the amount of the tax. The amount may be measured in many ways, but decided cases establish a clear distinction between the subject matter of a tax and the standard by which the amount of tax is measured. These two elements are described as subject of a tax and measure of a tax. Then I skip over the other portion. Then kindly take paragraph 13. Here, Miller, the retrospective argument is advanced. We may as well put aside the other argument that the Act is unconstitutional as it was passed on 2nd April 1975, but has imposed a tax on buildings with retrospective effect from April 1, 1973. Creation statute law so and so has stated the meaning of retrospective. A statute is deemed to be retrospective which takes away or impairs any vested right acquired under the existing laws, or creates a new obligation, or imposes a new duty, or attaches a new disability in respect of transactions or considerations already passed. But a statute is not properly called a retrospective statute because a part of the requisites of its action is drawn from a time antecedent to its passing. It has, however, not been shown how it could be said that the Act has taken away, or impaired any vested right of the assessees before us, which they had acquired under the existing law, or what that vested right was. It may be that there was no liability to building tax until the promulgation of the Act, earlier the ordinance. But mere absence of an earlier taxing statute, cannot be said to create a vested right under any existing law, that it shall not be levied in future with effect from a date anterior to the passing of the Act. Nor can it be said that imposing the building tax from an earlier date, any new obligation or a disability has been attached in respect of any earlier transaction or consideration. The Act is therefore not the Act is not therefore retrospective strictly in the technical sense. Then we have para 16. The court had occasion to examine the validity of retrospective levy of sales tax in so and so, and it was held that that was not beyond the legislative competence of the state legislature. Nor can the choice of April 1, 1973 as the date of imposition of building tax be assailed as discriminatory with reference to Article 14 of the Constitution. It will be enough for us to refer in this connection to the following passage in Union of India versus so and so, which was a case where the Central Excise and Salt Act be dubbed as arbitrary, even if no particular reason is forthcoming for the choice, unless it is shown to be capricious or whimsical in the circumstances. When it is seen that a line or a point there must be, and there is no mathematical or logical way of fixing it precisely, the decision of the legislature or its delegate must be accepted, unless we can say that it is very wide of the reasonable mark. It has not been shown in this case how it could be said that April 1, 1973 for the levy of the tax was wide of reasonable mark. On the other hand, it would appear from the brief narration of the historical background of the Act that the state legislature has imposed the building tax under the 1961 Act, which came into force. And when the said Act was finally struck down as unconstitutional by this court, a decision taken on so and so, the intention to introduce a fresh bill for levy was made clear in the budget speech of 1970-71. Now, with this notations, please take now paragraph 33. Well, we may skip over 33. I don't think that is important. Kindly comes to Millard, paragraph number 51. 51, 52 Millard are the quotations of those statutes. (62 Millard). This argument can be answered in three ways. First, learned counsel could not point to any of the cases before us in which such a question could have been said to have arisen. It cannot therefore be said to have arisen for consideration. Secondly, the building tax being a non-recurring tax payable by the owner once for all without any recurring liability, the question of passing it on to the tenant by splitting it up in proportion to the number of years of tenancy cannot be said to arise. Thirdly, the learned counsel have not been able to refer to any provision of the so and so Act under which the building tax could be taken into consideration in fixing the fair rent of the building, etc. Then finally, my lord, no merits. My lord, the only difference is between this case and our case is where in the 1980 Supreme Court case, my lord, it was a one-time affair, and in our case, it is a recurring affair. Now, please consider, my lord, whether, my lord, the same principles can be incorporated or imported, my lord, in our case. But I would be respectfully submitting, my lord, the Supreme Court has specifically said the fact that it operates from a date antecedent to from the passing of the act does not make it retrospective. In my case also, as I have tried to demonstrate, my lord, that this is a recurring liability, you have to go on paying. A new system is being introduced. There has to be some ironing of creases, some sharp edges over here and there. Therefore, go on paying. After the new system is put in place, whatever is the difference, that is recoverable. That is payable, if not paid, recoverable. So therefore, over here, when a new system is being introduced, whatever would be the outstanding balance difference, that is to be recovered. Therefore, in my very respectful submission, the principles over here would apply, and as the Supreme Court says, it is not wide of reasonable mark.
Yes.
The phrase of the Supreme Court. They only to recover the balance. Well, other submissions have been made. Article 14, my tenants have gone. I may have taken lesser rent. Now, if you put in a higher valuation, from whom do I recover? So these are, no considerations in my very respectful submission. But still, kindly have a look to one judgment. You can go. Present sale. But the hardship aspect might have shown me a provision from our judgment itself, from our statute itself. Let's please have a look to me one judge now, 77 seat. But kindly have a look to me one paragraph from 1970. This is under the Income Tax Act, 1977, Volume 3, Supreme Court Cases 305. 77 3 305. 305. But these are all, please recall, those judgment under this Debt Recovery Act, Securitization Act, where you have to deposit the entire amount to prefer an appeal.
Yes.
These provisions are also there in our KMC Act also, that these hardships, are no ground. Often, the forum of appeal becomes an onerous one because of the conditions imposed. But this is one of such cases under the Income Tax Act. Please have a look to only one paragraph, 35. I don't want to multiply decisions on this. To us, there appears to be no justification to depart from the normal rule of construction according to which the intention of the legislature is primarily to be gathered from the words used in the statute. It will be well to recall the words of Rowlatt in so-and-so, that in a taxing act, one has to look merely at what is clearly said. There is no room for any intendment. There is no equity about a tax. There is no presumption as to a tax. Nothing is to be read in, nothing is to be implied. One can only look fairly at the language used. Once it is shown that the case of the SSC comes within the letter of the law, he must be taxed, however great the hardship may appear to the judicial mind to be. Our statute, of course, looks into hardship aspect. But I don't trouble your lordship, my lord, on what grounds a statute can be challenged. There is no question of any legislative incompetence over here. Well, Article 14, my lord, explained by the other judgment, there is the Kerala building, that there is no Article 14 violation. There is no other constitutional right violation also. So, my lord, under these limited scope of challenge in my very respectful submission, the exceptions that have been carved out by the Supreme Court, my lord, for a challenge to the validity of an act, but are not satisfied or they do not arise in this case. But I don't want to cite judgment on that unless my junior wants me to cite one. না দরকার নেই। Adverse result, hardship, these have all been taken care of by judges. These are my submissions. And we had only one thing, we had only to just to remind that 2022 volume 12 Supreme Court cases 185 already placed before your lordship. Part 9A statute, the validity thereof can be challenged only on the ground that you have to show that part 9A has been violated. That 2022 judgment which I have placed. Part 9A. Whatever Supreme Court has said, I am saying so. So that part 9A statute can't be challenged under part 3. The Supreme Court has said. Yes, you express your shock before the Supreme Court. Don't express your shock before me because I am not the author. Yes. You express your shock in the appropriate forum.
Yes, Mr. Mazumdar. You are the only one.
In fact, my lord, since Mr. Banerjee says so, but 9th schedule statutes also, speaking in favor of Mr. Banerjee, 9th schedule statutes also can be challenged now. Supreme Court has.
Only one limitation.
Yes.
Only one limitation.
Yes. But the Supreme Court says there is only one limitation, it must be inconsistent.
Yes.
Shall I start today or on Monday?
So let's finish.
Today, very well. Then, my lord, may I just summarize? First, my lord, we deal with the submissions made on behalf of the KMC made by Mr. Kaur.
Thank you.
I'm grateful.
But first, I may want to make it clear because this will take care of many of the judgments cited on behalf of KMC as well on behalf of the state, that it is within the competence of Union Parliament or state legislature to enact laws with retrospective effect. No doubt about it. It is also within the competence of the Union Parliament or the state legislature to make or enact declaratory statutes. There is no doubt about it. However, the facts and circumstance of this case is not relatable to a situation of declaratory statute or a statute with retrospective effect or a statute which is sought to be given a clarificatory effect, just like removal of doubts, etc. But in this case, what has happened? A division bench of this honorable court has determined that the period of limitation for assessment would be 3 years. True, my lord, there cannot be any cavil to that provision. I was just hearing Learned Advocate General, that Learned Advocate General appearing for the state was questioning the, or in an indirect way, was questioning the legality or the validity of the judgment rendered in Sahu Jain case. I put the question to myself with all humility, is it permissible? Factually, my lord, again I will stand corrected by the learned counsel, senior standing counsel as well as junior standing counsel. The judgment rendered by the Honorable Division Bench in Sahu Jain case was not challenged by the state in its executive wing or supported by any state action. The judgment was only challenged by KMC which is only a creature of the statute, not, my lord, the creator of the statute, so as to say. So, my lord, so what we have from Saugen is that a fixed period is given. 3 years would be the period of limitation, and obviously it will be relatable to section 179 2D at any time would stand substituted. If your lordship takes the provisions as it then stood, and the provisions, if we take the provisions as it stands now, your lordship will find whatever has been done, it is just like, my lord, a cosmetic change. Just like giving the same provisions have been given a new set of apparel, have been put in a different kind of jacket, but it is all the same. My lord, I would beseech your lordship, one judgment I would like to cite, though in reply, my lord, this is the very recent judgment rendered by the Honorable Supreme Court in Madras Bar Association case, where the Honorable Supreme Court had the occasion to consider these kind of submissions made on behalf of the union by the learned attorney and how these submissions have been binned by the Honorable Supreme Court. But before that, my lord, may I just take your lordship one by one? So what do we have, my lord? The judgment rendered by the division bench of High Court was not interfered by Supreme Court. Again, a fact which cannot be disputed. Thereafter, review was filed by KMC, which was dismissed. And the SLP challenging the order dismissing review was also rejected by the Supreme Court. Straight away. State of West Bengal, though, was a party to the proceedings and represented was and did not challenge the DB order. State legislature enacted the Amendment Act of 2022 during the pendency of SLP challenging the order dismissing the review petition. The said fact was not brought to the notice of the Honorable Supreme Court. Next, the state legislature amended section 179 2D so as to give overriding power to, that is the language used, so as to give overriding power to KMC for making periodic assessment. So, 3 years now stands substituted by 6 years. So, my lord, whatever was laid down by this court, the Honorable Division Bench of this court, has been rewritten. My lord, the whole object of any validating statute is that if any defect is pointed out by the court, that defect should be cured by a legislative exercise to bring it in conformity with the law laid down by the court. It is not that, my lord, that they suppose the court had held, my lord, let us take a hypothetical situation. The court would have held that at any time should be a reasonable time without specifying the period. Then it may be possible, or it might have been possible for the state legislature to make an enactment saying that according to us, reasonable time would mean 6 years. But that is not so. The court here not only pointed out that at any time, that expression gives an unguided power, unbridled power to KMC to make assessment for any period, maybe 20 years, 30 years, 15 years, whatever it may be. But the court made it clear that this should be only 3 years and nothing more. Now, my lord, now kindly take 179 2D. Therefore, in my respectful submission, I would borrow this expression from the recent judgment of the Honorable Supreme Court, which I will place, seeks to abrogate the judgment rendered by DB with retrospective effect. Now, my lord, now another submission was made by Mr. Kaur that what about the proviso inserted to section 180? That was inserted by the same amendment. Now, my lord, kindly take the amendment for once. My lord, let me take your lordship to the relevant provisions. Kindly take for once. Just kindly give me 1 minute, my lord. First, my lord, if your lordship kindly takes my writ petition, Sahujan writ petition, page 19.
Page
19. Because, my lord, the provisions 179.2 has been
19 you
quoted.
said, right?
Sorry, my lord.
19.
19. I'm sorry. Yes, 19 of the writ petition. Paragraph 45. My lord, kindly take paragraph 46 first.
Yes.
This was the provision that was relevant at that point of time. Kindly take, my lord, 46 for once. May I just read out for your lordship kind consideration? May be revised on the expiration of each such period, provided that when the annual valuation of any land or building has not been revised on the expiry of any such period, for reasons to be recorded in writing, the previous annual valuation shall continue to remain in force until it is so revised. Then, my lord, the second proviso is relevant, provided further that the municipal commissioner may, on the expiry of such period, revise the annual valuation of such land or building at any time, and such revised valuation shall take effect from the beginning of the quarter from which the annual valuation would have been revised under this clause. So, my lord, suppose, my lord, in my case, what happened, just, my lord, for the sake of the specifics, sometime in 1999, my lord, the KMC thought it appropriate to, my lord, to make periodic assessments with respect to the building of Sahujan. That is the premises in question. And that was, my lord, rolled back to 1984-85. So, my lord, this gave, my lord, this kind of power is not conceivable in any statute. My lord, this is unheard of. Then, my lord, after that, while employing this provision, while using this provision, they raised bills for the periods commencing from either third quarter of 84-85, or I will give the specifics. It is 84-85 till, my lord, 99-2000. So this is the situation. Now, my lord, kindly now take what is now being done. This is the amendment. This is paragraph 45.
Yes.
First, DI. DI is relevant. Why, my lord? Because notwithstanding anything contained in this act or any judgment or decree or order to the contrary, the annual valuation of such land or building, my lord, kindly take I, may be revised at any time, not beyond 6 years. So, my lord, from the date of expiration of each such period, and such valuation shall take effect from the beginning of the quarter from which the annual valuation could have been revised. So, my lord, now 6-year period is given in place and state of 3 years, which has been determined by this honorable court. This is point A. To the best of my understanding, DI can never be retrospective. DI can only be prospective. Even if it is prospective, it seeks to abrogate, my lord, the provision for limitation as specified by the Honorable Division Bench. It is a direct, my lord, incursion into the judicial process initiated by the state government in its legislative wing. This is point A, my lord. Point B is most important, which affects me very badly. And if your lordship compares II with the then second proviso, your lordship will find there is no material change. Where it had already been made or revised beyond such period, the same including realization of property tax on the basis of thereof shall be deemed to be valid, and any outstanding property tax on such revision shall be recoverable. So, my lord, whatever assessment has been made for any time, at any period, during any period, all those assessments, despite there being any judgment to the contrary, would stand validated. That is their concept of validation. So, in true sense, my lord, the defect which was pointed out by the Honorable Division Bench is again reinstalled in this new avatar. This is a new form. Well, I will just kindly, my lord, bear with me. My lord, I will just say this is a very interesting submission. My lord, what happened? My lord, I'm not having that judgment today because I thought, my lord, Learned Advocate General would continue. That was my misunderstanding. I am to blame. So, my lord,
Mr. Mazumdar, then we'll have it tomorrow. What
my
time
lord,
tomorrow?
kindly not tomorrow, my lord. Out of Calcutta. Kindly give me Friday, I will conclude.
Not Friday.
Monday, I will conclude. Monday, I will conclude because my lord, I have to place the judgment because each and every submission made by Learned Advocate General today and by Mr. Kaur.
Today is Monday, so whole week you're out.
Sorry, my lord.
Whole week you're out.
My lord, I will be back earliest Wednesday, latest Thursday. So, my lord, I cannot make, I would not dare to say that kindly keep it on Thursday and I don't turn up. That's not appropriate on my part. That will be extremely inappropriate.
Thursday we can try.
Sorry, my lord.
Thursday.
My lord, that is why, my lord, either Wednesday or Thursday I'm coming back.
Then Monday.
Wednesday, I can't come back before Wednesday, that's for sure. I may come back on Thursday. But, my lord, I want to continue and conclude. Because, my lord, kindly give me some time. On Monday, my lord, I will not take more than 30 minutes. Your lordship has seen me, I am economical that way. I am generally economical because, my lord, court's time is very precious.
More economical for the client.
Kindly keep it on Monday. I will conclude on Monday. Within 30-40 minutes, I will conclude. My lord, but I will place reliance on the new judgment and making it clear to all my learned friends.
Monday. You have to make some submissions. As soon as he's over, very little, but keep it short. I'll keep it.
But he won't keep it short.
He.
No, I made my opening once, just a few submissions. Over and off.
My lord, I will deal with each judgment. I will demonstrate from the judgment that this was all in my favor. Kindly keep it on Monday. Man, I'm very sorry, extremely sorry, my lord. Extremely sorry.
The Advocate General for the state. Keep it for further hearing on Monday. Monday with.
Grateful, my lord. So grateful to your lordship. May I take your lordship's kind leave, my lord?